Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
I'm on mute. Good morning. Good morning, everyone. Happy Wednesday. Today is Wednesday, January 15th of 2025, and we are halfway through the first month of 2025. That's kind of crazy, doesn't it? Kind of crazy. And we're here today to continue our conversation on the Turk case. So many of you are from Massachusetts. We have a big Massachusetts following here because of the Karen Reed case. So many of you have never heard of this case, which I found so interesting. Dr. Ingolf, aka Harry Turk, we're going to call him Harry for purposes of our streams. Harry Turk was a renowned surgeon, robotic surgeon from Dover, Mass, who very sadly and tragically, allegedly, although it seems he confessed, strangled his wife, Katie McLean, to death in May of 2020 during the panty. We cannot use the full word of the lockdown situation, but I call it the panty. May 15th, I believe it was, of 2020. My notes serve me. Dr. Turk is still sitting in Norfolk County Jail, awaiting his trial, which is supposed to start on March 25th of this year, which is the week before the Karen Reed trial is supposed to start, in the same courthouse. Judge Cannone had been assigned to the Turk case, and then recently she was taken off the Turk case and the Brian Walsh case, but she has been specially assigned to remain on the Karen Reed case. So that's interesting. It's crazy. It's crazy that you guys live in Boston, never heard of it. People are telling me, and I'm hearing from people, please be respectful, because a couple of Katie's friends have reached out to me. They miss her terribly. They are outraged with the way this case has been delayed. It'll be 5 years in May. And Harry is still sitting in a Norfolk County pokey. Look at James Lynch is in Boston. He didn't know anything about this case. They say that what happens in Dover stays in Dover, apparently. Very wealthy suburb of Boston. Hi, Moon Goddess. I did see the full wolf moon. Werewolves of London. That was awesome. Beautiful. Had some great moonshine, too. Great. I mean, I wasn't drinking moonshine, but the moonshine was beautiful here. It was a little cloudy. But I did get to see it, and I felt it, too. I think I felt it, too. I think I had an outburst that day, a little outburst that morning. But, you know, it's full moon energy. What are you going to do, right? So a couple of Katie's friends have reached out. They miss her terribly. They are outraged that this is taking so long to get to trial. Part of the reason that it's taking so long is because of the Proctor problem. Proctor, Michael Proctor, who is going to face Judgment Day perhaps today. He's in Framingham today in front of the Massachusetts State Police. trial board. So if that story breaks while we're here, we'll cut to that and talk about, what punishment, if any, Trooper Michael Proctor is going to receive due to his abhorrent investigation and text messages during the Karen Reed case and trial. So it's happening today. I don't know if they're going to reach a decision today. So I don't know if we're going to hear about it today. So we'll see if it happens. I'll bring it to you, of course, as always. And because Proctor's now, on the Brady list, and Proctor was involved in the Turk investigation and the Walsh investigation, all of his text messages now become fair game. And now there are emotions flying back and forth to see what they can get, what they want to get. There's a lot of motions in lemonade coming out right now, as we call them, because the closed captions referred to them as motions in lemonade once during the Karen Reed trial. And so we've adopted that phrase. For those of you who are not familiar, motions in lemonade are made prior to trial to keep certain evidence out and or rule on admissibility of evidence to get it in before the start of the trial. So there are a bunch of motions flying around, but I kind of wanted to start from the beginning because we never covered it. So during the first stream on this case, we went over the Commonwealth statement of the case and what their version of events is. And then we read the defense's statement of the case, which was had a lot more detail in it, let's just say, about the relationship between Harry and Katie, when Harry met Katie. Diane, thank you. Diane says the urology office I worked at 10 years ago would refer to Dr. Turk. Interesting. Ted Daniel is live in Framingham and is reporting on what happens with Proctor. Amazing. Thank you, Katie. I'll keep up his Twitter feed. So if anything happens, hopefully I'll see it. Excellent. This is a very collaborative channel. You guys help me because, it's just me. It's just me and some amazing, amazing moderators who run this channel. I need an assistant. So Ted Daniel says, on the road in Framingham today for Trooper Michael Proctor's trial board hearing. It's not public. And media is being kept in a designated area away from the building. So he's there. He's boots on the ground. And we'll see what happens there, hopefully, during the course of this stream today. Proctor needs to be locked up. Yay, Amanda, yay. Bunch of new members here. Yuri's math teacher is back. Hi, Yuri's math teacher. We've missed you. Jennifer Giuliano is a new member. Everyone, welcome, Jennifer. Lori Life 360 for the win, gifted 5 memberships. And so welcome to the 5 who were randomly selected by YouTube to receive them. And thank you, Lori, for always being so kind and generous to this channel. And she loves it here. And she's been here for 9 months. So I think you guys are going to like it here. Tumultuous relationship, to say the least, between Harry and Katie. They had a drive-through wedding in Vegas. I think they started dating in 2017. They had a drive-through wedding in Vegas, I believe, at the end of 2019. During 2019, Harry Turk was brought up on some federal charges, which we're going to go over. By February of 2020, he was fired from his job at St. Elizabeth's. And apparently, according to his own filings, he was depressed and he was upset. And culminated in the alleged strangulation and death of his wife, Katie McLean, in May 2020, during the height of the panty. They had been back and forth. They signed a post-nup. I think he asked her for a divorce, something like maybe 6 weeks into the marriage. And then she told him she wanted to reconcile. They signed a post-nup. He signed over half of his house to her. He was living in a trailer in Florida. He was very scared that he might catch the virus and die, according to his own papers, which were not signed by him, but his attorney. And apparently, maybe he lost his temper. He claims that she hit him with a glass and that the next thing he remembers, he grabbed her And then he realized that she was dead. Clearly a lot more to that story, but I think that if he's going to try and assert any sort of self-defense, he was going to need to testify. And yes, McLean, thank you. Thank you, Jennifer. Thank you, Jennifer. Also, Steve Roca, her ex-husband, ROCCA, is pronounced Roca. Thanks, Jennifer, for pointing that out in the comments to me, because I like to, urologist. He was a urologist. I think he mostly operated on prostates robotically. And so during the first stream, we went over some old footage of him doing his robotic surgery. If you're buffering, just refresh your browser. I don't think it's me. Unless the YouTube is, I'm on Ethernet, so it should be fine. But the mods will let me know. If you are buffering, just refresh your browser. Yeah. Very sad. Okay, so he was a prostate surgeon. Thank you. Thank you, Johnny. Thank you, Johnny Bags. Johnny Bags. And so we went over a lot during the first stream. I've linked that stream down below in the show notes if you'd like to catch up. Right, and then he accidentally dropped her in a pond behind a vacant home that apparently he had been touring to buy, because according to him, she was threatening him that she was going to take half his house and kick him out again. She may have weaponized the 209A statute, according to him, of course, and his version is the only one we have left. But she did obtain a couple of restraining orders against him, and then he was not supposed to be in the house on the night of this incident because of that order, and yet he was, which led to this tragic end to the life of Katie McLean, mother of 3. And very, very sad. First, I want to take a look, because we didn't cover this last time. I want to show you the charges that he was brought up on by Maura Healey, who was the U.S. Attorney General for the District of Massachusetts back when this came out. And this press release is from November 7th of 2019 from the Office of the Attorney General. And it is entitled, Surgeon Resolves Allegations of Falsely Billing Mass Health. And reads as follows. Boston, a Dover doctor has agreed to pay $150,000 to resolve allegations that he caused his employer to inappropriately bill the state's Medicaid program, Mass Health, for portions of surgical procedures that never took place and office visits that he did not attend or supervise, Attorney General Maura Healey announced today. Under the terms of a settlement agreement, Ingolf Tuerk, a medical doctor who practiced urology at St. Elizabeth's Hospital in Brighton, will pay $150,000 to resolve allegations that he caused improper billings to Mass Health of over $31,000. Dr. Turk must also implement a multi-year compliance program at his own expense if he continues to practice medicine in Massachusetts after 2019. False billing is a serious issue that hurts people in need of health care, said Attorney General Healey. It is important that all doctors follow the law, and our office will aggressively pursue those who overbill our healthcare system. The AG's office alleges that Dr. Turk instructed his residents and fellows to document the use of ultrasound probes during partial nephrectomies, kidney removal, in patient medical records, even when they had not been used during surgeries. The AG's office also alleges that Dr. Turk billed Mass Health for office visits that used billing codes indicating he was present or supervising other medical professionals, despite patients only being seen by an unsupervised resident or fellow. The AG's Medicaid Fraud Division continues to be a leader in recovering funds for Mass Health. In fiscal year 2018, the division recovered more than $45 million for the program through civil settlements and criminal fraud convictions. Members of the public who are aware of similar practices by other physicians or healthcare providers should call the AG's office. They have a Medicaid Fraud Division. There's the phone number, or file a complaint through the Attorney General's website. This matter was handled by Assistant AG Philip Schreiber and investigator Catherine Suttmeyer of AG Healey's Medicaid Fraud Division. Substantial assistance was provided for the Board of Registration in Medicine. So it doesn't look like his medical license was taken away, unless that is something separately that the medical board does. Doesn't look like he was brought up on any criminal charges. It looks like this was some sort of settlement, and he agreed to pay $150,000 to make it go away. But then in February, he was terminated by the hospital. So this is a guy, 6'3", big guy. We watched some video of him during the last show. And rode a motorcycle, things like that. We've got a good sense of him. He has a voice that sounds like Arnold Schwarzenegger. Many people said they were listening to the stream and they thought it was Arnold Schwarzenegger talking. So there's that. I want to take a look at a piece from NBC 10 Boston. This was 5 months ago. This is from August. And this is when the defense firm in Turk, who, by the way, his attorney is Kevin Reddington. You may remember that name. Kevin Reddington is one of the best attorneys, apparently, criminal attorneys, defense attorneys on the South Shore, I guess, in Boston. And he represented Jennifer McCabe. He may still represent her during the Karen Reed trial in her motions and things when they wanted to obtain her cell phone records. He may have also been in the courtroom during her testimony. And he also represents, I believe, Lindsay Clancy as well, unless he has been replaced. But last I heard, he was representing Lindsay Clancy. He's been around a long time. People say he's a good guy, funny guy. But let's take a look at what NBC 10 was reporting back in August. And then we're going to take it back and we're going to go back and review a motion to suppress the initial statements of Harry, and see what his claims are. And we're also, by reading that, going to get a lot more facts about what happened in the aftermath of the evening of May 15th of 2020. Let's take a look at this piece first, since Proctor is going to maybe face the music today. Just let me know that you can hear it.
From the Karen Reed trial is making waves in another high-profile murder case. A prominent Dover doctor is accused of killing his wife. When the trial date nearing, his attorney is now arguing for personal text messages and emails from investigators who worked the case. It all stems from the stunning testimony of embattled Massachusetts State Trooper Michael Proctor. You may remember his crude text messages about Reed came to light when he was on the stand. NBC 10 investigator Ryan Kath has been reporting on Proctor's impact on other murder cases. He's live in Denham tonight with today's developments. Ryan.
And Glenn, the closely watched Karen Reed case played out right behind me, ending in the mistrial last month. But now the ripple effects are being felt in the same courthouse. Ingolf Tuerk entering Norfolk Superior Court in a suit and handcuffs. The once prominent surgeon who appeared on billboards is accused of killing his wife, Kathleen McLean, inside their Dover home in May of 2020.
I'm going to just take it back and let you see that billboard. I put this on my thumbnail, but it says robotic assisted surgery.
Billboards is accused of
robotic assisted surgery made me famous. Bringing it to Brighton makes me proud. And then there's a sort of like an animated or a cartoon type version of him. And it says St. Elizabeth's Medical Center on it. And then up on the upper right-hand corner of the billboard, which you can't really read because it's very small, it says Dr. Ingolf Tuerk, Chief of Urology. I'm not quite sure why they had him on a billboard, but it's interesting how far he's fallen.
Killing his wife, Kathleen McLean, inside their Dover home in May of 2020, then dumping her body in a nearby pond. Investigators say after they found the doctor unresponsive at a Dedham hotel, he later confessed to the crime while recovering at the hospital.
I think it's a legitimate motion.
4 years later, Tuerk's attorney Kevin Reddington arguing that they should have access to text messages and emails that police, including Massachusetts State Trooper Michael Proctor, exchanged about his client and the case during the murder investigation.
They give me a notice. They say, okay, look, you've got lousy investigation. You've got misrepresentations. You've got totally inappropriate references to, the defendant who's being investigated.
Reddington is talking about receiving this letter from the Norfolk DA's office, which the NBC 10 investigators first reported last week.
No news so far.
The letter references Proctor's crude and unprofessional text messages about Karen Reed to coworkers.
To say the least, crude and unprofessional. It's a lot worse than that when he calls her a whack job C word, and then the judge makes him say the word.
friends and family, while also saying the trooper is suspended without pay while an internal affairs investigation plays out.
From all accounts, he didn't do anything wrong. She's a whack job.
I think it certainly raises a red flag as to whether or not his investigations are done without bias.
Attorney Rosemary Scapicchio also received the letter and represents defendants in 3 murder cases that Proctor investigated. She plans to make a similar request for communication among law enforcement.
So this could set quite a precedent.
It could and it should, because we're trusting law enforcement to do their job in an unbiased way.
Reddington told us Proctor played a major role gathering evidence in the Dover investigation and said he's only now asking for the text messages and emails because of what the U.S. Attorney's Office uncovered in their rare probe into how the Reed case was handled.
If it wasn't for the federal authorities, nobody would have known about this issue.
That motion wasn't argued today. That will happen at the next court date in September. The trial is currently slated for November. It's worth noting the judge, Beverly Cannone, is the same judge who presided over the Karen Reed trial. We're live tonight in Dedham. Ryan Kath, NBC 10 Investigators.
Not anymore. Now it's been reassigned to to Judge Mark Hallal, who is coming in from, I guess, Suffolk County to Norfolk Superior. And so the new judge is Judge Hallal. Yep. This is going to be so bad because of Proctor, says Heather. And Sarah says, Michael Proctor helping all sorts of defendants. So Dr. Turk, Harry, is charged with first-degree murder, which carries a life sentence in Massachusetts. And my guess is that they're making all of these motions to try and maybe find something to have the jury perhaps determine that it's second degree and not first degree. Second degree could carry life with the possibility of parole somewhere between 15 and 25. Don't quote me on those exact numbers because I did look it up before the stream, but you know, my brain is mush and it's got a lot of stuff in it. So I think that's really kind of the best that they can do. I mean, he admitted to it. They made a motion though. They made a motion to suppress all of his statements. We're going to take a look at that first. This is back when Judge Cannone was still on the case. Let me put all my windows together. Where did my windows go? Hang on. Okay, that's my guess. I mean, that's probably what they're going to be going for here, is to try and get the jury to believe it's second degree. First degree requires premeditation and planning. And then I look at some of the motions he's filed recently that we haven't gone over yet, and I'm thinking everything that you're asking for and everything that you're saying in your motions is giving the defense, I mean, the prosecution, the Commonwealth, more ammunition to say that this was premeditated and you had a lot of motive. So it's interesting, and we're here for it. Oh, thank you, Lori, for your super sticker and for tuning in from Canada. I appreciate you so much. That's very generous of you. Thank you so much. Jojo says, I've known Reddington for a long time. Good guy, but I can't imagine doing his job. I know. I mean, look, it must be much harder to be I've never been a criminal defense attorney, never claimed to be. I'm a civil litigator for over 30 years in New York. I'm not barred in Massachusetts. I'm admitted and licensed in New York. But I imagine as a criminal defense attorney, it is so much harder to represent your client when you believe that they are innocent because the stakes are so much higher, right? But every defendant deserves a good defense and a good defense attorney, and he's private counsel. He's not assigned counsel, and imagine that Turk can afford to pay for. All right, so this is a motion that was originally made all the way back when Judge Cannone was still the judge in well, it's not stamped, but I think, according to my notes, if I can read them in the darkness here, this motion to suppress was made in August of 2021. This case has been going on for so long. People are outraged. This is filed by the defense. It's an omnibus motion to suppress statements and physical evidence. Now comes the defendant, Ingolf Tuerk, in the above numbered indictment and moves this court for an order suppressing for use in evidence all statements and evidence derived therefrom made by the defendant to detectives of the Massachusetts State Police. We went over the list of all of the troopers and MSP personnel that were involved in this case, and it's quite long, that were also involved in the Karen Reed case, including Nick Guarino, Tully Fanning, and several others. In support hereof, the defendant states that he was interrogated by the police while in the Norwood Hospital under medical care and treatment. He was admitted to the hospital and we're going to, you know how I hate typos, punctuation, spelling errors, grammar. I'm like a grammar snob. Again, there's a lot of that in here, a lot of incomplete sentences. I don't know who does his writing. Perhaps he doesn't do his writing. Reddington, perhaps he has someone else doing it, but he was admitted to the hospital in virtually moribund state. He was highly intoxicated and suicidally depressed. As a result of medication, his depressed mental state, and medical treatment, the defendant did not make a knowing, intelligent, and voluntary waiver of his constitutional rights to remain silent, and his right to counsel, in contravention and violation of his rights, secured him under the 5th, 6th, and 14th Amendments to the United States Constitution and the concomitant provisions of the Massachusetts Declaration of Rights. And this we spoke about the other day. Allegedly, he waived his Miranda rights and self-snitched, like totally self-snitched. We went over this the other day. Criminal lawyer Bruce Rivers. My thoughts and prayers go up to him in the tragic death of his son, Michael. Many of you also watch Bruce Rivers, and I do not know. I look uncomfortable in my chair. Now I'm just trying to, there's a thing like banging up against the, I don't know. I'm trying to get the base of it right. Okay, there we go. And now I lost my train of thought. What was I saying? I don't know. It'll come back to me. Prayers up for a criminal lawyer, Bruce Rivers, who I do not believe has done a video on the self-snitching of Dr. Turk. I could be wrong, but I don't think he's posted much since the tragic passing of his son, Michael. And that was in November. So prayers up to him. Commonwealth versus, so this is the memorandum of law in support of that motion to suppress the statements and physical evidence and search warrant of the defendant's hospital room, auto, and home. Statement of facts. On May 15th of 2020 at 11:42 a.m., Dedham police received a call from Stephen Roca, who reported that his ex-wife, Katie McLean, was missing. Her family last saw her in the presence of her husband, the defendant, at approximately 1 a.m. And then it starts a new sentence. When they were together at the defendant's home, located at 29 Valley Road in Dover, Massachusetts. Footnote 1 points out, as we went over last time, because of the post-nup, the defendant signed a deed granting McLean a 50% interest in his home, as well as a prenup recently. Well, it says prenup agreement, but we know because we went over it last time, it's a post-nup. Post-nup is similar to a prenup, except it's signed after the marriage. And it's very common. Katie's friend Vanessa told Stephen that one of the defendant's friends, Kurt, texted her a screenshot of a text he received from the defendant, Harry Turk, stating, quote, "Kurt, I'm sorry, bother, but she is a vindictive devil. She played us all. I'm really sorry, brother, but she manipulated us all. Love you, Harry." Roca further noted that Katie and the defendant's cars were at the Residence Inn in Dedham. Dedham police responded to the Residence Inn and proceeded to room 228, registered to the defendant with a room key. They knocked with no response and then entered the room without a warrant. Upon entry, they observed the defendant unresponsive, lying in the bed in jeans and a long-sleeved shirt. He had cut wounds to his left wrist and a noticeable laceration, but it doesn't say where the laceration is. A bottle of Glenlivet Scotch was nearby that was half full. There were also pills, in parentheses, aspirin and Pepsid, as well as a bloody knife and tissues. Police noted cuts and lacerations on his arms and legs, which begs the question, how would they see the legs with jeans on? That's in the document. That's not my snark. A syringe was located under the bed. He was given Narcan and taken to the hospital. The two vehicles were parked side by side. The police seized the vehicle and brought them to the police station to be held pending a search warrant. I don't know. That should have been a separate paragraph. It's not. It's going to bother me, but I'm going to try to keep it together. Okay, a syringe was located under the bed. He was given Narcan. If he was given Narcan, there had to have been some sort of opioids, right, in his system, because there are certain things that Narcan will not work on. So if the only pills they found were aspirin and Pepsid, it begs the question, what was in the syringe? Well, of course, the defense is not going to point that out here, but if it was something like heroin, they might have had a better shot at getting this. Well, I'm not going to give you any spoilers right now. Dover police worked in conjunction with Dedham authorities to attempt to find Katie. They pinged her phone. They went to the defendant's home that was now occupied by Katie and her 3 children. Stephen Rocco was present, getting the 3 children. He told the police that the bedroom door was locked. Police searched the home and made forced warrantless entry into the bedroom. Upon entry, they observed broken glass. Her phone was found in the bedroom. Dr. Turk and Katie had a tumultuous relationship. She alleged assaults and erratic behavior. She obtained restraining 209A orders evicting him from his home at the height of the COVID pandemic. We have to strike that because YouTube hates that word, and they go through with AI and they strike your stream if you say it, or I don't know. I don't understand, but those are not my rules. On February 5th of 2020, the defendant was arrested and charged with strangulation/suffocation and assault and battery on a household member. All right, so this is new information. Who's the household member? This doesn't really help you, defense, because in February, 3 months prior to him allegedly strangling Katie, resulting in her death, he was arrested and charged with strangulating another household member? Duh. Anybody has any information on who that household member was? I mean, you don't have to tell me like their name or anything. Was it a child? Because I thought they had 3 children living in their house, her 3 children. And I don't know if he had children also that lived in the house. She contacted the police on a regular basis, accusing Dr. Turk of many allegations, providing names of people to interview to support her case. Okay, well, isn't that a good thing that she's got people to back up her stories? Footnote 2 says, at the same time, she was reaching out to Dr. Turk, seeking to reconcile, asking for certain demands, such as being placed on the deed and signing a post-nup agreement. I feel like the more the defense points out all of these things, the more motive it gives Harry, the more he might have planned her demise. But that's just me. Like I'm just not sure how all of this detail helps the defense. Well, I guess for purposes of this motion, she contacted the police, the district attorney's office, and the courts requesting changes to the terms of release. Police interviewed Dr. Turk's Harry's friend Kurt Pfannenstiel, who told them that he was friendly with both. Harry and Katie were married in Las Vegas in February, approximately 2 weeks after the alleged strangulation. Okay, so my dates were wrong on that. So they were married in February of 2020. In Vegas, we learned it was like a drive-through chapel. Once they were married, they had, quote, problems and argued a lot. Kurt texted Harry and Katie on a number of occasions in the past few weeks after Katie told him Harry was back. Kurt related the text he received from Harry suggesting that she, quote, deceived them all. He expressed concerns. His last contact with Katie was the day before on May 14th, 2020 at 7:28 a.m. Katie texted and asked how he was doing. The police interviewed Roca and his children. They confirmed that they were at the defendant's home where they were residing with their mother. On the evening of May 15 of 2020, they were at the home and all ate dinner. The oldest daughter, I'm going to call her S, went to her room while Harry, Katie, and the other two children played a board game. I believe that the oldest daughter was somewhere around 17 or 18. After the game, the son and G, we'll call her, went downstairs to watch television. Harry and Katie remained upstairs. The son and G eventually went to bed and did not see Harry or Katie. G had difficulty sleeping and went to get a melatonin to help. She heard the dog barking by their bedroom and heard loud thumping noises. She heard Harry breathing at the bottom of the stairs, but could not see as it was dark. S, the oldest daughter, was in her room. She got up to get a glass of water. She heard Harry and Katie arguing. They were seated on the living room couch. G said the next day that she did not see Harry or their mother. She related black marks that smeared and looked like mascara on the floor. Oh, yeah, poor woman. Which would have meant that she may have been dragged, like face down. That's horrific. The children related incidents of violence where the mother said he tried to strangle her and the son saw him try and cut her hair. They said she was nervous when he was around. They apparently preferred to live in his house without him present. Vanessa Pettigrew was interviewed. She stated that she was Katie's client in her, quote, wellness business, end quote. This should say they, but it says the became friends. Harry was chief of urology at St. Elizabeth's Hospital. He got her a job at the hospital. Harry had issues at work and took a medical leave. Issues at work. Okay, that's like putting it lightly. He got fired. He got fired because he was forced to pay a $150,000 fine for fraudulent billing of Medicare. So call it what you will. But yeah, those were his issues at work. I don't know that he took a medical leave. I thought he was fired. But they're going to spin it as the defense would spin it. On May 16, 2020, the residents in room 228 and Harry's home at 29 Valley Road, Dover, Massachusetts, were searched with a warrant. The warrants were executed in the early morning hours on May 16th. On Saturday, May 16th, 2020, investigators went to the Norwood Hospital where the defendant was a patient. The interrogation was preceded by Miranda warnings and was lengthy. State police and Dedham police were the interrogators. All right, so this is where perhaps Proctor and or some of his cronies may come in to this case. And remember, these papers were filed in August of 2021, which was before the murder of Officer John O'Keefe. So some of these names did not have stains on them back when this motion was made, when this investigation was conducted. But knowing what we know now and knowing what happened in the Karen Reed case, enter Proctor, says Batty, enter Proctor. Oh, thanks, Lori, for another super sticker. Appreciate you. Canada's watching, folks. Canada's watching too. Back to one. The defendant made a lengthy statement in response to numerous questions. He admitted that they were arguing and Katie hit him in the head with a drinking glass. Does that sound familiar to anyone? It's eerily reminiscent of what they thought happened. Anyway, at first, in the Karen Reed case, when they responded to the hospital, and Yuri Bukhenik said that he thought it was a domestic. Perhaps the glass was, I don't remember if Yuri said he thought she hit him in the head with a glass, but I think that that's what they were thinking. He did treat it initially as a domestic because that's what he was told by the EMTs. He said in his testimony, I believe, in my opinion. I'm going to clarify that and quantify that a million ways to Sunday. The things that I say are my opinion. My opinion with my more than 30 years of experience as a practicing attorney in New York. When people accuse me of lying, these are not lies. These are my opinions based on facts that I've read in police reports, in interrogation reports, facts as reported by the MSP and others. Some of you know what I'm talking about. Some of you are like, well, what is she talking about? I base my opinions on court documents and other investigatory official documents that I review in every case. The argument started in the living room and continued to the bedroom. Once struck, he reacted and choked Katie. Okay, so this is his statement that he gave to the police, okay? His statement was that he admitted they were arguing and Katie hit him in the head with a drinking glass. The argument started in the living room and continued to the bedroom. Once struck with the glass, he reacted and choked Katie. He panicked and disposed of her body in a pond in the neighborhood, weighted down with rocks. As a result of his statement and directions, police were able to locate her body. The defendant was placed under arrest at the hospital. Okay, so this is the day after the argument, which was the same day that he was found in the residence inn, which was the same day that she was reported missing. All of this is happening in the same day, May 16th, 2020. Number one, the defendant did not make a knowing and intelligent waiver of his rights to remain silent and right to counsel at the hospital. Yes, it's so true, Ducati girl. I love how the Karen Reed case is now a standard measure. It is in Massachusetts. Because we learned in the Brian Walsh case that the MSP, including Proctor, do know how to do a proper investigation. We went over a lot of documents and investigative police reports in the Karen Reed and the Brian Walsh case. We know Proctor knows how to do it. But in Karen Reed's case, he just didn't. Because within 16 hours, he was going to pin it on the girl, according to his own text messages. Within 8 hours, he called for a tow truck to meet him in Dighton to seize her car without even having seen her car, based on the statements of Jennifer McCabe, Matt McCabe, and Brian Albert. And maybe allegedly something that he heard at the station from another trooper. Allegedly, in my opinion, according to the testimony, as I recall. Dr. Turk was admitted to Norwood Hospital on May 15th of 2020. A review of the medical records, Exhibit A, reveals that he required ICU care. All right, so he was admitted to the ICU. All right, wait, I just want to check the date on one thing. They didn't interview him until the 16th. Hold on. Yeah, that's right. They interviewed him on the 16th. On the 15th, they ate dinner. This must have happened in the early morning hours, right? On the 16th. All right. In any event, he was unresponsive, according to the medical records, when he was in ICU. He was suicidal. Transfer to the psych ward was considered due to his debilitated state. An MRI revealed chronic ischemia. Alcohol level was high, and psychiatric consult and alcohol withdrawal counseling was noted. His serum alcohol on admission was 0.226. He was literally comatose. Literally comatose. It's not really legalese. I have questions. Thank you, Team Brittany, for this nice reminder. Please post responsibly. Your opinions are your own. We do not give legal advice or any other professional advice. Thank you all for being here. Thank you, Brittany, for being here. And Scott and I have a $50 bet. Scott thinks Proctor is going to keep his job. I'm like, I'll take that bet because I think they need to make Proctor a fall guy. So we got a bet. on this today. We'll see. Carol says, however, Narcan does not bring you back from alcohol poisoning, so he had to have something else on board, in my opinion. May have given, yeah, in my opinion. Thank you for saying in my opinion. They found a syringe. They may have given it as a precautionary measure to see if it would work. Argument. A confession is admissible only if it's voluntary. Voluntariness has been defined as a meaningful act of volition, the product of rational intellect, and the result of a free and voluntary act. And here's all the case law to support that. As it requires waiver of constitutional rights, every reasonable presumption against waiver will be indulged. The court must have no doubt that the warnings were given and understood, and the constitutional guarantees were validly waived. In assessing the issue, the court must make the determination based on the totality of the circumstances to determine the validity of the waiver. Miranda warnings are required whenever there is questioning of a defendant in a custodial situation. It is clear that the interrogation in the defendant's hospital room by the detectives was custodial. Barely will any single factor be determinative. The critical question is whether, considering all the circumstances, a reasonable person in the defendant's position would have believed that he was in custody. If a reasonable person in the suspect's position believes he is not free to leave at the time of the interrogation, then he was in custody. The defendant was in the hospital. He was admitted in a virtually comatose condition. I thought it was literally. Now it's virtually. Okay. He was despondent and depressed. Well, how did you know he was depressed if he was in a coma? 2 detectives questioned him in this condition. He did not make a knowing and voluntary waiver of his rights to counsel and right to remain silent, and his statements and all evidence derived therefrom should be suppressed. The police did not have the right to make a warrant. This is point number 2. The police did not have the right to make a warrantless, unannounced entry into the defendant's home or hotel room. The evidence clearly shows that the police did not have the evidence to believe that McLean was in danger or any person needed assistance. I would disagree, but the warrantless entry into the defendant's home, followed by the warrantless entry into his hotel room, was without probable cause and did not validly come under the community caretaking exception to the rule requiring a warrant. At best, the police knew that the defendant was with his wife the night before. Both of their cars were parked in the hotel lot, and they may have argued the night before. The text to Kurt Pfannenstiel merely noted that she was manipulative and played them all. There was no indicia of foul play. In Canglia v. Strom, the Supreme Court held that where a man during an argument with his partner threw a gun on the table and told her to shoot him, the sentence ends there. The Supreme Court held that where a man during an argument with his partner threw a gun on a table and told her to shoot him, period. There's supposed to be more to that sentence. They separated for the night. His wife called the police the next day and expressed her concerns for his safety due to his erratic behavior and access to a firearm. The police perceived that he was a danger to himself or others and entered the home and made seizures of evidence. The Supreme Court held that the community caretaking exception to the warrant requirement did not apply. The court distinguished Katie v. Dombrowski, which was a search of a motor vehicle for a firearm. There's a difference between a motor vehicle and a home, and the court declined to extend the Katie, I'm sorry, that's Katie, not Cody, community service exception to homes. The facts of this case are eerily similar. In the instant case, the police had little or no probable cause to enter the defendant's home or his hotel room on a community caretaking exception, and all evidence obtained thereby should be suppressed. Criminal complaint and search warrants are annexed as Exhibit B. Oh, I hope we're going to get to see them. Oh, no, we're not going to get to see them because they're not attached to the document. I hate that. Well, maybe they'll be in another document. We can hope. Let's move on to the Commonwealth's opposition. See what they've got to say. The opposition was not filed until, let's see, when was this opposition filed? Motion was filed August 2021. Oh, let's get the scrolly thing. Oh, good. We're going to get some, I saw some names go by. So we're going to see who was involved in what here. What troopers were involved? This was dated November 17th. So August, 3 months later, opposition is filed. Usually they have like a week or two. When I was looking through the court docket, there were a lot of times that Harry did not come to court and he refused to appear in court. So there's that. A lot of delays in this case. A lot of delays. Friends and family are outraged. Would they have needed a warrant if the oldest daughter let them in? I don't think she can consent to a search. I don't think she was over 18. Poor police work, says Scott. You entered to look for life, not evidence. This is the Commonwealth's opposition to defendant's motion to suppress statements and physical evidence. The Commonwealth opposes the defendant's motion to suppress statements and evidence. The defendant's statements to police at Norwood Hospital were not custodial. Nonetheless, the defendant voluntarily and knowingly waived his Miranda rights, and his statements were made voluntarily as he was alert, calm, lucid, and answered officers' questions in a clear, responsive manner. And the tone of police during the interview was calm, sympathetic, and patient. I mean, okay. Is that what the reports said? That the police were calm, sympathetic, and patient? The police's warrantless entry into the defendant's hotel room and home was justified under the emergency aid exception, as police had an objectively reasonable basis on each occasion to believe that emergency aid was required. Factual background. Footnote 1 says, the Commonwealth anticipates that the facts recited herein will be presented through exhibits and testimony at the evidentiary hearing. On Friday, May 15th of 2020, family and friends of Katie McLean, the 45-year-old victim, became concerned when they were unable to locate her. Her 3 minor children had spent time with her the previous day and evening before going to bed in the family residence in Dover. In the morning, when they awoke, she was not there. Calls to her cell phone were not answered nor returned. At approximately 10:42 a.m., a hotel manager at the Residence Inn in Dedham called Dedham police. And then they have Dedham 911 call audio in parentheses here. The hotel manager reported to the 911 dispatcher that he conducted a wellness check of the occupants of hotel room 228, the defendant's hotel room, at the request of the victim's ex-husband, Stephen Roca, who requested the wellness check because he had received a disturbing message from his wife the day prior. The hotel manager knocked multiple times on the door, and when he did not receive a response, he opened the door. The manager told the dispatcher that he observed the defendant lying on the bed, and while he yelled several times to the defendant did not respond despite his eyes being open. Ooh. And then there's audio at 28 to 33 seconds. This must be on the Dedham 911 call. How did Steve Roca know that they were at the Residence Inn? I don't know. The manager noticed some bloody tissues on the counter, which is also in the audio. The hotel manager told the 911 dispatcher he did not have an opportunity to look in the bathroom, but he did not observe a female in the room, despite knowing that a female, the victim, was staying with the defendant. Guess he saw them check in together. All right. Hotel manager will be a witness. At approximately 10:45 a.m., Dedham police officers Joseph Ellis and Paul Cady, C-A-D-Y, were dispatched to the Residence Inn for a well-being check. 5 minutes later, Officer Ellis arrived at the hotel. The hotel manager communicated his observations to Officer Ellis. The hotel manager also informed Officer Ellis that Roca had told the manager that the victim's car was parked at the hotel She was not answering her phone and had left her children at home, which was very unusual. Based on the hotel manager's observations and concerns, Dedham police officers Ellis and Katie went to the defendant's hotel room, knocked several times, and announced Dedham police. When there was no response, officers Ellis and Katie entered the room. Officer Ellis observed the defendant lying on the bed unresponsive, but with his eyes open and occasionally moaning. The defendant had wrist lacerations consistent with self-harm. The defendant did not move when the police entered the room. Officers Ellis and Katie attempted to wake the defendant, but he remained unresponsive. The officers called for an ambulance. Officer Katie stayed with the defendant while Officer Ellis looked around the room for the victim. She was not there. On a small table, Officer Ellis observed a large kitchen knife with what appeared to be blood on the blade and several tissues with blood on them. I was going to say, where did the knife come from? But it's a residence inn, and the residence inn has a kitchen, and they give you such things as utensils and knives. Perhaps it was the residence inn knife. There was a half-empty bottle of Glenlivet Scotch by the bed. Officer Katie discovered a loaded, in quotes, loaded syringe under the defendant's mattress. Paramedics arrived and administered Narcan to the defendant, which had no discernible effect. Okay, so the Narcan didn't work. They observed cuts on his arms and legs consistent with scratches from brush. The defendant was transported to Norwood Hospital. After the defendant was transported to the hospital, Officer Ellis spoke with Stephen Roca in the residence inn's parking lot. Roca told Officer Ellis that he had become concerned as the victim had not been heard from since the prior evening, and it was incredibly unusual for her to leave the children at home. Footnote 2. It was also during the early months of the C-19 pandemic. At that time, there were in place executive orders issued by the Office of Massachusetts Governor closing certain non-essential workplaces and prohibiting gatherings of 10 or more people. See the C-19 Order number 30. Order further extending the closing of certain workplaces and the prohibition on gatherings of more than 10 people, issued April 28th, 2020. Is it like surreal for anyone to think back and remember that actually happened, and that like we were forced under government order to not get together with more than 10 people? It still kind of blows my mind. It feels like so surreal that happened. I remember it well. Ding, 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 ding. Big old dog says, so Dedham cops can determine where scratches on legs came from, but the ER doc can't tell where dog bites came from? Right. Or what caused those scratches to John O'Keefe's right arm. That is correct. Oh, Law Junkie says, the sheriff in Springfield, Massachusetts was recently arrested for DUI and refused the sobriety test at the scene. It was all on dash cam. Hi. Moving on. After the defendant was transported to the hospital, oh wait, I think I just read that part. Oh, about leaving the children at home, right. Roca also informed Officer Ellis that at 4:31 a.m., the defendant texted a family friend saying, Kurt, I'm sorry, brother, but she's a vindictive devil. She played us all. I'm really sorry, brother, but she manipulated us all. Love you, Harry. Roca informed Officer Ellis that there was a history of domestic violence and outstanding charges in Dedham District Court against the defendant for strangulation of the victim. All right, well, in the papers that we read earlier, it said he'd been arrested for strangling a household member. Is this the same charge? Questions. Due to the defendant's current medical condition, the fact that the victim's whereabouts were still unknown, the victim's vehicle was located at the residence inn, that nobody had heard from the victim since the prior evening, the domestic violence history between the victim and the defendant, and the text message sent by the defendant to the family friend, police began pinging the victim's cell phone in an attempt to ascertain the victim's location. Dedham police determined that the victim's cell phone was pinging in some woods not far from the family home at 29 Valley Road in Dover. But didn't they say that they found it in the bedroom? Okay, let's read on. That's what the defense said. Dover police were informed and went to the Dover residence in order to conduct a well-being check of the victim. That is also on the 911 call. When Dover police arrived at the Dover family residence at approximately 12:18 p.m., Roca was leaving the residence with his and the victim's 3 children. Roca informed Dover police that he was concerned that the victim was injured and locked inside a bedroom within the residence. Police entered the house through the garage and located the locked bedroom. Police used a Halligan bar. Halligan bar has entered the chat to force entry into the bedroom. I don't know. Chatters, tell me. If you're Steve Roca and you're concerned and the bedroom door is locked, would you bust the door down to see if your ex-wife, the mother of your children, was okay in there? I don't know. I'm just asking. Police checked the bedroom and walked through the residence, but were unable to locate the victim. At this time, police did not check the basement. Police continued to receive information regarding the whereabouts of the victim's cell phone, which provided several locations around Walpole Street at Cedar Hill. Police did not locate the victim at these locations. Why would they not have searched the basement? Okay, I'm going to take back everything I said about MSP knowing how to do a proper investigation, except this is Dover police. I have so many questions. Yeah, we don't have the incident report. Dad, you're right. We could probably do a FOIL request for it. If anybody has the investigative reports from Dover Police and MSP, I would love it so much if you would email them to me. I don't think they're going to be attached to any of these documents, and I was lucky enough, fortunate enough to gain access to those like before Karen retrial, so we had all that stuff. It's fan base at ngled.com. I'll put that up for a second. Or if one of the mods could put my email in the chat. Let me just put it up for a second. Thought I had a banner. Here it is. Fanbase at ngled.com. That'd be amazing. If any of you detect armchair sleuths out there, have them. I would love it if you would email them to me. That'd be amazing. Thank you so very much. At approximately 2:45 p.m., the final information from the phone indicated that it was located in Medfield, but with a radius that would include the family residence. Dover and Medfield police officers, different officers from those who entered the residence earlier that day, went to the residence again and observed black markings on the floor leading from the master bedroom to the garage. Okay, well, they didn't see them the first time? Broken glass on the bed in the master bedroom and blood on the bedspread. I mean, hold on. What time did they first bang the door down and go in there? 12:18 p.m. The initial Dover police responder didn't notice any of this stuff. It wasn't until 2:45 p.m. that this stuff was noticed. Right, Kimmy. Seems like the MSP have a dislike for searching basements. I see what you did there, and I'll allow it. Except that this is apparently Dover police. But we'll see. We'll see if the MSP do search the basement, because then, if they do, we'll know that they know how. Magnolia Gypsy says, notice how local PDs in this state are less competent than any TV show cops? Oh, the Las Vegas cops are outraged, you guys. They're outraged. They're so nice. Welcome to Massachusetts, says Misty and Eddie. Misty and Eddie. And your math teacher comes in and tells Kimmy it's beneath them. Ba-dum-bum. Snarkiest, funniest chat on the internet. Although there's nothing funny about the very sad death of Katie McLean. I think she was only 45. And then Team Brittany comes in with Yuri's math teacher. What a low blow that was. You guys are on it today. Agree, Zoe. Black markings on a floor is pretty vague. Are they talking like scuff marks from shoes or gouging drag marks from a suitcase or something? How big are these black marks, right? I think that they said earlier that the daughter said it was like mascara. So the cops that show up at 2:45, 2.5 hours later, they find black markings on the floor leading from the master bedroom to the garage, broken glass on the bed in the master bedroom, and blood on the bedspread. Medfield police officer Sergeant Colby Roy, sounds like a character out of Landman, called dispatch and requested dispatch call the victim's cell phone. The cell phone was heard ringing in a purse located in the master bedroom. Okay, so the cell phone the whole time was in the bedroom. Well, I guess it wasn't in plain view. I never leave. I don't leave my cell phone on. My phone is always on silent. I hate having my phone ring when I'm places or waking me up. I'm surprised that hers was on, but I guess some people leave their phone on. Luckily, because then they found it. Although apparently they still have not been able to unlock it, and it's almost 5 years later. We'll get to those motions later. Those are recent motions. They've had it apparently hooked up to Gray Key. And recently, defense made a motion to say, give us the phone. We want you to give us the phone so we can have our forensic examiner look at it and try to open it. And it's been apparently hooked up to Gray Key for like 5 years, and they still can't unlock it. I have questions. Was it Guarino that couldn't unlock it? The lover you know. The lover you know. Oh, I see what you did there. Who in the Blue Duck authored these motions? They have 5th grade Trooper Paul Charm to them. Literally. Yeah, literally. He's literally comatose. Thank you, just ducking around. You're correct. All this is motive. I know. This is Commonwealth papers, though. Now we're reading the Commonwealth papers. The opposition to the motion to suppress the statements. Officers photographed the phone in its location and left the residence. Oh, for the love of the traveling Mary, they photographed it. They photographed the phone. You know where they didn't photograph the phone in its location? During the murder investigation of Officer John O'Keefe. They did not photograph the phone in its location where they found it. No, they didn't. No, we don't really know who picked up that phone. We don't really know who had custody of that phone. There's no chain of custody report or log that we saw them turn over in this exact case. A 26-page chain of custody report for Trooper Michael Proctor's work phone. But they photographed the phone in its location and left the residence, securing the residence in anticipation of a search warrant application. Police also searched in wooded areas with the assistance of canines, called local hospitals, and went door to door in Dedham and Dover. Wow, you know where they didn't go door to door? In Canton. During the investigation of police officer John O'Keefe. I know, thought the pinging was, look at that, Mama Buck. Interesting too. The phone was pinging in the woods, they said, first, right? And then they said the final information from the phone indicated that it was located in Medfield, but within a radius that would include the family residence. So what? Are these GPS things on the phones, the pinging of the phones, accurate or not? If they had the phone pinging in the woods and then in Medfield, but within a radius that would include the family residence, how big is that radius? And doesn't that mean that John O'Keefe could have been in the house? Based on whatever the location on that phone was telling them, I submit to you, oh, yes, it could. Oh, yes. Oh, yes. Oh, yes, he could have gone in the house, which was how many feet away from where his body was allegedly found? I don't know, 30 feet away, 40 feet away, door to door. Amazing. Perhaps it was a Wednesday. Didn't do it in John O'Keefe's case. Didn't do it for him. But in Dover, they do it. Canton, not so much. Canton, not so much. Oh, especially when one of the Canton police officers named Kevin Albert is the brother of the homeowner of 34 Fairview. But, no big whoop, nothing to see here. Pin it on the girl. Let's move along, in my opinion. Hmm, hmm. They went door to door. Through interviews conducted that evening, police learned that the defendant had left the Dover house pursuant to court orders in February, according to the search warrant affidavit. In early May, the defendant and the victim decided to reconcile, and the defendant returned to the area and rented a room at the Residence Inn. I think during some of the filings you read the other day, we found that he was living in a trailer in Florida. Magnolia Gypsy GPS is not always exact for a number of reasons, right? Right. But they want you and me and Massachusetts and the world and the jury to believe in the Karen Read case that John O'Keefe's phone never moved and its location remained under his body on the lawn from the time she hit him at whatever time they're saying it is now until his body was found in the morning. I'm taking that down for now. If you need it, you can go back to it. Tracy says the phone wasn't in the bed. Yeah, I know. Apparently it was in her purse. Thanks, Tracy, for the super chat. Teacup Kraken says, Turk's biggest mistake was not having friends or family in the MSP. Magnolia Gypsy says, they talk about Kevin like he's some wayward guy, but really it does seem like he is the family fixer. Back to the Karen Read case. Crazy. This has given us some insight into some other investigations in the nearby area. 2 years almost before Officer John O'Keefe was murdered. In the days leading up to May 15th, 2020, notwithstanding the court order, the defendant had been staying at the Dover residence. That evening, the victim's minor children reported to police that the defendant was at the family residence the night prior, and they had dinner as a family and played a board game. The children then went to the basement to watch TV until they went to bed, and the defendant and the victim stayed in the living room. During the night, one of the children heard the dog barking by her mother's bedroom door, and loud thumping noises. You know what else didn't happen? Chloe didn't bark in the morning when all that activity was going on outside of 34 Fairview. She heard the defendant walking around and breathing at the bottom of the stairs. Another child said she could hear her mother and the defendant arguing at approximately 1 a.m. All three children told police that when they woke up, there was no sign of their mom or the defendant. They told police that they saw dark markings throughout the house that would smear if you touched it. The children had not seen the defendant's car since he returned to town, and the only vehicle parked in the residence that night was their mother's vehicle. This is all according to the search warrant affidavit, which would be nice to see. The investigation continued throughout the night. At approximately 2 a.m. on May 16th, 2020, police executed search warrants for the Dover residence. Wait a second. Their investigation continued through the night. At 2 a.m., they're still investigating in Dover? Wow. As well, both cars were registered to the defendant. One car was primarily used by the defendant, and the other car was primarily used by the victim. At 8 a.m., Dedham police around the clock, they're working. Around the clock. Around the clock. And no shade to Katie McLean at all and her importance, because every life is important. But they didn't do that for dead Boston police officer John O'Keefe, a fellow brother in blue. Did they? Nope. Because he wasn't missing. At 8 a.m., Dedham Police Detective Deborah Gonski, is that really? Gonski, she's Gonski, was informed by Norwood Hospital that the defendant was awake and resting. According to hospital staff, the defendant had woken up at approximately 1 a.m. asking for water and acting normally. At 5:19 p.m. on May 16th of 2020, police interviewed the defendant in a conference room on the second floor of Norwood Hospital. Attached photographs of the conference room. Oh, they took photographs of the conference room? And the interview was audio recorded? Knock me over with a feather. Dedham Police Detective Deborah Gonski knows how to do it. The defendant waived his Miranda rights and agreed to speak with Massachusetts State Police Trooper Jeffrey Krakowski and Detective Gonski. Now, riddle me this, Massachusetts friends. I thought that the Massachusetts State Police did not become involved until there was a fatality, because remember, in the John O'Keefe case, they said, yeah, we're not coming because he's not dead. Do you remember? Does anybody, am I remembering this? We're not going to come to this. We're not reporting to the scene because he's not dead yet. Here, Katie McLean is missing and MSP is all over it. Am I misremembering? Attorney wannabe. You're an attorney wannabe? Sounds like I will need to take time off from work this spring to fit these Norfolk County cases on my view list. Well, it's going to be in the same building as Karen Reed. There might be more seats available in the Turk courtroom, so you might have a shot. Jury selection schedules to start on Turk on March 25th. KPT says you're right. James says you're correct. Zoe, it wasn't snowing in May, so perhaps MSP is more likely to respond. Law Junkie said, they said that 100%. Unless there's a fatality, MSP doesn't respond. Team Brittany backing me up, as always, as is Anonymous Canadian Girl. Well, that's interesting though, right? It's interesting because she's missing. And they didn't call the CERT team. And that's what the CERT team does, Yuri's math teacher, right? Didn't we learn that the CERT team typically investigates missing persons? And that's what they look for. They're not evidence collectors. They're not CSI. They're not the crime lab. That's what the CERT team does. Cusco Wright is very proud of his Twitter law degree, his or her. ELA says that's another reason Proctor should be fired. Unable to do proper investigation. Karen Reed should have never gone forward. This seems like a good time to check in with Ted Daniel, see if he's got anything cooking on Michael Proctor's trial board hearing in Framingham. The last thing he posted was January 15th. Okay, I'm just going to interrupt this stream for 1 second to show you this. Because, in case you want to screenshot it and use it as your screensaver, hang on. I want to remember where I was here. Oh, we're right at Krakowski. So in case I forget, because I will, because. All right, let's first watch Ted Daniels' video on Twitter. Hang on. He says, on the road in Framingham today for Trooper Michael Proctor's trial board hearing. It's not public, and meat is being kept in a designated area away from the building. And then he says,
the evidence and the charges, the board. Hi, everybody. This is Ted. I'm outside the State Police headquarters in Framingham for Trooper Michael Proctor's trial board hearing. I've also heard this referred to as a court-martial. Trooper Proctor will appear before 3 senior-level troopers appointed by the colonel. Lieutenants are above.
Are they friendlies? I just want to know, are they friendly? Is Ted Daniel looking good today? Doesn't he usually wear glasses? Something looks different. I don't know. His hair looks blonder. I don't know. Just saying.
Of a representative from Division of Professional Standards or Internal Affairs will act as the prosecutor, lay out the evidence and the charges. The board will listen to all that. Proctor will have a chance to call any of his own witnesses, and then the board will decide guilty or not guilty on the charges and make a recommendation to the colonel as to discipline. The colonel gets the final say as to what happens. Don't expect any sort of decisions to be announced today.
Oh, all right. So the colonel, the new colonel, Jeffrey Noble, I think is his name. He's a Jersey guy. I don't know anything about him other than that he's from Jersey. What witnesses do you think he'll call? Look at the first post underneath it. Yes, there it is in all its glory. Hold on. I stand with Michael Proctor. In case any of you would like this for your screensaver, enjoy. Is Brian Albert going to be a witness for him? Sees the day, wants to know. Oh, Sarah in shock and horror says that Jeffrey Noble had some disciplinary actions against him in New Jersey that were interesting. Oh, thank you, Sarah. I didn't know about that. Anybody want that? Yeah, this is what goes on out there in the as such cesspool of Twitter. I know a lot of you aren't on it. Maybe some of you are, but this is what's happening today. And then there's that. With 57 comments. Well, back to the document. Don't expect any decision today. Well, at least now we know, according to Ted. No, that's not what I'm looking for. I want the other one. Stop. Stop. This has to stop. Where'd it go? Just disappeared. Hold on. Oh, for the love of the traveling Mary. Where's the papers? Sometimes things disappear. Sometimes I disappear. But talk amongst yourselves for a second. I want to go back and try and find it. That's the decision. Okay. That's not what I want. That's the decision on that. So where are the rest of the papers? There it is. Okay. I found it. It came back. Just revealed itself. It just revealed itself. Can you believe it? So there he waived his Miranda rights and he's in there with MSP Trooper Kakowski and Detective Gonski. Oh, look, there's an interview. It's probably attached as an exhibit. We probably can't see it though. Initially, the defendant told investigators that he had limited memories about the previous night and did not know how he came to be in the hospital. Later, the defendant told police that he and the victim had been drinking and argued. The defendant said that the victim had thrown a glass at him and he thought that he grabbed her around the neck. The defendant then requested a break in the interview. It was 7:29 p.m. The interview resumed 43 minutes later at 8:12 p.m. with Trooper Kakowski and Dedham Police Detective Richard Porro, Porro, who had taken Detective Gonski's place in the interview. Why did Gonski go Gonski? The defendant told police that he and the victim had argued about text messages, and then the defendant strangled the victim. I mean, talk about self-snitching. Argued about text messages. Text messages are bad. We learned in the papers we read the other day that she, on more than one occasion, would take his phone while he was sleeping and go through his phone. It needs to stop. It needs to stop. And we learned also during the defendant's statement of the case, according to the defendant, he was texting with someone named Kate Kelly, who was an old friend that he had never been romantically involved with. And he told Katie, oh, even Kate Kelly's rooting for us when they were when they were reconciling. And then, according to him, Katie said, give me your phone. I want to read those text messages. And he said, no, babe, let's not go backwards. Let's only go forwards. The text messages are just going to make you mad. We have to look to the future. We're reconciling. And somehow she wrestled the phone away from him, saw the messages with Kate Kelly, and got mad because I think he disparaged her in some of those messages or something. Yeah, according to him, exactly. According to him. But none of that stuff is getting in Robin's Landing unless he decides to take the stand, which will make this trial hella more interesting. He said that when he realized he had killed her, he panicked and realized he needed to dispose of the body. When asked where he put the body, the defendant again claimed he could not remember. So again, this is the defense motion to keep all of this out, to keep all of this confession out. And his argument is, I was on drugs, I was hammered, I was drunk, I was literally comatose when I came into the hospital. There's no way I could have voluntarily waived my constitutional rights. Therefore, you must throw out my statements and all my self-snitching. It says here, the transcription of the defendant's interview with police is attached to Trooper Kukowski's Massachusetts police report and was generated by the software SpeakRight. I'm not familiar with SpeakRight. But guess what? If they had recorded statements of all the witnesses in the John O'Keefe murder, and those audio recordings were generated by the software SpeakRight, like when certain witnesses in the case changed their testimony 5, 6, 10 times, and then got on the stand and said, oh, Lenk wrote that down wrong. I didn't say that. Oh, Proctor wrote that down wrong. I didn't say that. I never said that. We'd probably be watching, hearings to exclude the software SpeakRight because it's defective. And there would be arguments from some rando expert that they found from Canada or somewhere that, SpeakRight has had to redo their entire software because it's so inaccurate. And it was like transcribing audio recordings of victims and defendants and witnesses wrong. Just did. Yeah, right. Brittany. They must be getting that confused with Speak Wrong. Right? Imagine having audio recorded statements on a software to transcribe them. That is such amazing technology. They must have just invented it. Oh no, you mean they had that back in 2020? Yeah, they did. They did. They didn't wear body cam, not in Canton. Couldn't afford it. They wanted some kitchen that cost a whole lot of money. Police, let's wish Robin's Landing luck in her perfect focaccia. You've thrown out 4 so far? All right, we're rooting for you, and we want to hear how it is. I love focaccia, and you can do it, girl. You can do it. You can do it. James says because they can't speak right, they all speak wrong. I'll allow it. You don't know what focaccia is? Team Brittany? Team Brittany, you don't have any Italian in you? Kind of like, how do I describe it? It's like a delicious Italian bread. It's fluffy. Usually it has like olive oil and rosemary on it, and it's a little salt. Some of the nice Italian restaurants give you a little focaccia in a basket on the table when you go. When you go to a nice restaurant, Little Italy. Yes, yes. Attorney Wannabe pointing it out. Misleading and inconvenient that Harry never mentioned that he panicked and never mentioned the pond, etc., in his statement that we read last night. Yep. Kylie. Love that Melanie gets more and more feral over the blatant lies and obfuscation in the Karen Reed case. Oh my gosh. It's kind of like pizza toast. Yeah, kind of. Focaccia. Savory goodness, says your math teacher. Oh, did any of you watch Auntie Deb? I don't know if it's last night or the night before. Somebody pointed it out to me that he's doing like some awards. He had nominations the other night for the awards in the Karen Reed case, and superlatives like most likely to become president and best dressed. And he announced the nominations, and I'm proud to say that I received like 3 nominations. I'm so excited. I don't know who's voting or when it is or what we need to wear. If there's going to be an award ceremony, if I'm going to get to win something. I think I was nominated for. I think I was nominated for most popular, which is crazy because my fellow nominees are like Karen Reed, Alan Jackson, David Yannetti, and Turtle Boy, and me. So that's cool. I don't think I'm going to win that one, but I'm going to prepare my speech just in case. And I think I'm nominated for best YouTube background or, something like that. And also best eyes. A lot of competition, but, go to Auntie Deb's, watch it, learn how to vote. I don't know how to vote. Give me some votes. Scott, we have to do that. We should have a category, most likely to send trolls in the chat to Block Island. There should be a moderator. There should be a best moderator superlative. I'm going to have to point that out to Auntie Deb. I think we're going to have to, I'll allow it. If you can think of any others, go comment on his stream. Guarino was best dressed. I think the nominees in that category were something like Karen, Alan Jackson. I forget who. There was a number of nominees. Watch it. Oh, thanks to Cotty Girl. Best Law Tuber easy. Oh, thank you. Thank you for congratulating me on my nominations of something that is completely fake, unknown, and it's going to be great. Oh, thank you for being proud of me. I appreciate you guys so much. Okay. Oh. Can the Karen Reed's defense subpoena the Speak Right Company for all records related to January 29th, 2022 on interviews? They would have to have a good faith basis to think that any of these interviews were actually recorded. But that's an interesting thought. It'd have to be evidentiary, relevant. And you know how those Rule 17 motions go in the Karen Reed case? Interesting. Interesting point. Thank you, Patriotic. Back to the document. Oh, now Team Brittany and Scott are arguing. Oh, okay, there's going to be a tie between Team Brittany and Scott for best moderators. I'll allow it. Oh, FC Dixit said, we spent several chats choosing the superlatives. Great fun. I nominated you for several categories. Oh, thank you, FC Dixit, Sherilyn. Thank you. Thank you. Thank you. They had best rant. Oh, it is. Thank you. This is Navy, actually. It's Navy. Thank you. All records related to the Karen Reed case. I bet the software transcribes in real time, so the files go to a SpeakRite server. Are you talking about in-court transcripts? Because I know that they are transcribing the sidebars. But I'm sure they ordered trial transcripts too. Or maybe not. Maybe they didn't incur that expense. That would be a huge expense. Stenographers in the chat, tell me how much it would be for 9 weeks of trial testimony to be transcribed. How much would that transcript cost you? Oh yeah, Esty, is Esty here? Esty, I think Esty was nominated for a couple things too, like best dressed, best sign. Yeah, that's it. Best dressed. Esty was in there. Esty, you still didn't tell me if your name or your handle comes from the Taylor Swift song. Esty that I listen to in the morning with my daughter every day on the way to the bus stop. Esty, no, but you get the foot behind the head thing. I can almost do it, but not quite. Yes, I think you were honorable mention for that one, right? The blonde who can put her feet behind her head in her uncle's office or something like that. I'm talking about recordings that MSP may have actually made when interviewing the witnesses so that they could keep their story straight later. I believe everything was recorded. Well, I mean, everything's worth a shot, but you know, Karen needs money. Karen needs money. She's $5 million in debt. All of this stuff costs money. Luckily, Robert Alessi has come on board for free. But it's a point. It's a good point. It's a good point. Is there a song with your name? Yes. Come on, Team Brittany, help me on this one. ST, a friend of mine. Oh, day. Was it No Body, No Crime? Maybe it's No Body, No Crime. I think it is. I think it is. I'm going to go with that until Team Brittany corrects me. Definitely on the same album. No Body, No Crime. It is. Emmy, I'm right. It is. SD, you got to listen to it. Get on your Spotify and listen to it. Oh, you got honorable mention for biggest flirt? Yeah, it's funny. I wish we had a ballot that we could go over. How we get in the ballot? Right, Patriotic Act. Just because MSP says they didn't record doesn't mean it's true. In fact, they said they didn't record so much that I actually believe they did for their own use. Oh, so they could make a timeline and get the story straight and statements. Although, if you're a friendly, don't you leave your recorder in the car? I don't know. I think it's SD was a friend of mine. That's right. SD was a friend of mine. SD's a friend of mine now. Love our girl, SD. Yes, you should listen to the words. I thought for sure that you took your name from that song. Okay, moving on. Police explained to the defendant that they wanted to recover the victim's body so that her family would have closure. Eventually, the defendant explained that he was aware of a vacant house in Dover, which bordered a pond, and that he had submerged her body in the pond. The defendant stated he may have put a rock on top of her. The defendant gave Trooper Kukowski specific directions to the vacant house, the pond, and to the victim's body. The interview concluded at 8:59 p.m. All right, so how long was this interview? Because, you know, all the ones in the Karen Reed case were like 5-10 minutes. $7:29, they took a break for 45 minutes. 5, so they started at 5:19. So they went for about 2 hours, and then they took a break, and they went from 8:12. I'm to 8:59. It's like almost a 3-hour interview. He self-snitched. Guy's very highly educated. I mean, he's a robotic surgeon. What? All right, I guess not so smart. As reflected in the audio recording throughout the interview, police were calm, patient, allowed ample time for the defendant to respond to each question, and sympathetic. Okay, so I guess according to, I can't wait to hear this audio recording, because guess what? That's coming in at trial. Oh, if this motion is denied, but it would be if the motion was granted. It would be suppressed. It wouldn't come in at trial. Using the directions, Massachusetts State Police and Dover police officers located the victim's body approximately 15 to 20 feet from the shore of the pond. Did they measure? partially submerged, face down. This is tragic and so sad. And thoughts and prayers go to all of Katie's friends and family. I know how much you loved her because you've told me that you knew her from the gym or other places, or your friend was her best friend. Some of you were best friends with her and you miss her so much. And no matter what was going on in their relationship, she did not deserve this. Obviously, I mean, that goes without saying. When her body was recovered, she was clothed only in yoga pants. 2 rocks weighing 16 pounds were located in her pants. The autopsy revealed a fractured hyoid bone, petechiae in both eyes, bruises on the neck and within the neck muscle, and bruising on the scalp and brain. The cause of death was determined to be strangulation and the manner homicide. Okay. A couple of things I want to point out in this paragraph. They measured where her body was, even though it was in a pond. No, it wasn't snowing, but what do you think's more difficult to do? Measure in a pond or in snow? Number 2, the autopsy revealed a fractured hyoid bone. That is a bone in your neck that is typically found when someone is killed by strangulation. It is not typically found in a hanging, which is why when they found the independent autopsy forensic pathologist, Dr. Michael Bodden, who is very, very famous, was hired by the family or the plaintiff's attorney in the Sandra Birchmore case. They discovered a fractured hyoid bone. And don't quote me because I don't recall if the original medical examiner in Sandra Birchmore found a fractured hyoid bone or not, but it should have been a tip that she did not die, Sandra Birchmore anyway, from a self-unalived hanging from a doorknob. A fractured hyoid bone was also found in the body of Shannon Gilbert, who is one of the Gilgo victims, and it has been Long Island, Suffolk County PD's hypothesis or theory all along that Shannon Gilbert was not a victim of the Long Island serial killer, that her death was an accident or a drowning, and yet she too had a fractured hyoid bone. Petechiae in both eyes can also come from strangulation, is when the blood vessels in your eyes burst. Actually happened to me the first time I gave birth, which is bizarre. But I must have been pushing so hard that it happened and I had like blood vessels burst in my eyes. Guess I was really just wanted to get that baby out. Bruises on the neck and within the neck muscle, and bruising on the scalp and the brain. Cause of death, according to this medical examination, medical examiner, was strangulation and the manner homicide. Contrast this with the John O'Keefe autopsy report, in which the manner of death was undetermined. And the medical examiner, Dr. Irene Scortibello, despite being maybe, in my opinion, badgered by Proctor and Bukhenik to change her manner of death on the death certificate to homicide so that it would be easier to pin it on the girl, Karen Reed, she wouldn't do it. Contrast that also with the manner of death in the Sandra Birchmore autopsy and death certificate, which said suicide. Despite the fact that Trooper Guarino, I just call him Trooper Guarino, missed 35,000 text messages between Matthew Farwell and Sandra Birchmore on Matthew Farwell's phone, even though they had Sandra Birchmore's laptop and all of those messages were on her laptop. So there's that. Oh, look, you had it too, Stephanie? Stephanie had petechiae in her eyes after pushing out a 9.5-pound baby after 20 minutes of active labor. It happens, right? It was my first baby. I was like young. I was like, what's going on? You did too? All right, good. I'm glad I wasn't the only nut. My mother was like, what happened? I don't think she had ever seen anything like it before. Took a while to go away too, right? Regina too. Although my first child was 6 pounds and change. I have 5, so I can't remember. I remember my twins were 3.5 pounds each. And my final, my last, my fifth, my favorite, if she's watching, was 9.5. But I had a C-section with her. Yes, Robbins Landing, Shannon Gilbert had a broken hyoid. Yep. All right. Wow, that's interesting. I didn't redo anybody. Okay, cool. Look, we know. We know. That's what petechiae are, right? Argument. The defendant's statements and Miranda waiver were voluntary and knowingly made. The defendant argues, and remember, this is the Commonwealth's papers. Defendant argues that statements made to police while at Norwood Hospital during the course of a police interview should be suppressed because he was admitted to the hospital in a virtually comatose condition the day prior and was despondent and depressed and did not make a knowing and voluntary waiver of his rights or make voluntary statements. The defendant was not in custody at the time these statements were made. Nonetheless, he voluntarily and knowingly waived his Miranda rights. I bet you they have it on audio. The defendant's statements to police were made voluntarily as he was alert, calm, lucid, and answered officers' questions in a clear, responsive manner. And as reflected in the audio recording, throughout the interview, police were calm, patient, allowed ample time, blah, 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 sympathetic. Miranda warnings are only required where an individual is subject to a custodial interrogation. All right, so their argument is going to be twofold. I guess it's going to be, number one, he wasn't really in custody because he was in the hospital. And then they go on to say, an individual is subject to a custodial investigation when a reasonable person in the suspect's shoes would experience the environment in which the interrogation took place as coercive. The court considers the place of the interrogation, whether the officers have conveyed to the person being questioned any belief or opinion that he's a suspect, the nature of the interrogation, including whether the interview was aggressive, informal, or influenced in its contours by the person being interviewed, and whether at the time the incriminating statement was made, the person was free to end the interview by leaving the interrogation or by asking the interrogator to leave, as shown by whether the interview terminated with an arrest. No one factor is dispositive. And they go on to say that each interrogation stands on its own. When a defendant challenges the admission of a statement allegedly resulting from custodial interrogation, he bears the initial burden of proving custody. The police interview of the defendant while at Norwood Hospital did not constitute a custodial interrogation. The interview took place in a neutral location, a conference room down the hall from the defendant's hospital room. The defendant was not handcuffed, and only 2 investigators were present at all times in the conference room. As heard in the audio recording, again, let's point it out, audio recording of the interview, the officer's questioning was not aggressive, and officers allowed the defendant to discuss at length the history of his relationship with the victim. The officer's tone throughout the interview was calm, sympathetic, and informal. The defendant requested and took a 43-minute break. The record demonstrates that this was not a coercive custodial environment, and a reasonable person would not consider himself in custody at the time of the police interview in Norwood Hospital. I can see both sides of that argument. I can see the side where you're like, I'm in the hospital, I can't just leave. The cops have me in this conference room, I have an IV pole. I don't know. I can see both sides of that, but we'll see what Judge Cannone does with it. Wouldn't it be so interesting? I'm breaking from the document for a second to say, wouldn't it be so interesting if Michael Proctor had an audio of Karen Reed's interview when he interviewed her at Dighton? And all of her statements that she allegedly made to Proctor, because we know from some of the other witnesses who took the stand that Proctor didn't always write things down right. Couldn't it be argued then that Proctor's statements about how much Karen Reed had to drink, the things that Karen Reed said to him about making a 3-point turn and other things like that, maybe he got it wrong. Maybe she didn't speak to him at all, and he just went back into his cruiser, and him and Yuri made up a whole bunch of ducking BS. Maybe. But it would have been so great if nearly 2 years later, they had this audio recording of Karen Reed's interview, especially since they were going to take her car and phone, and they had already considered her to be a suspect. Why wouldn't he audio record it? There's no good reason. And that is exactly why wicked smart patriotic says that's why I'm thinking it would be a good idea to subpoena the recording company. Mm-hmm. Even if this court were to find that the defendant was subject to a custodial interrogation while at Norwood Hospital, the defendant made a knowing, intelligent, and voluntary waiver of his Miranda rights. For any statement made during the custodial interrogation to be admissible at trial, the Commonwealth must prove beyond a reasonable doubt that the defendant received the constitutionally required Miranda warnings and voluntarily, knowingly, and intelligently waived his Miranda rights before making the statement. For a waiver to be valid, the defendant must understand the warnings themselves, but need not fully appreciate the strategic consequences of waiving these rights. The validity of the waiver is assessed in light of the totality of the circumstances, including the manner in which the interrogation is conducted, whether Miranda warnings were given, the defendant's physical and mental condition, and the defendant's individual characteristics such as age, education, intelligence, emotional stability, and experience with the criminal justice system. The defendant was informed of his Miranda rights and confirmed both orally and in writing that he understood these warnings. Okay, they had him sign something. Imagine a witness that you're interviewing having them sign papers. Didn't do that in any of the John O'Keefe investigation. Nope. Some of the witnesses they didn't interview for 18 months to 2 years later. And this is how they did it in May of 2020. At the time of the interview, the defendant was familiar with the criminal justice system as he was facing charges of strangulation and violation of a 209A abuse prevention order in Dedham District Court. Moreover, the defendant, a doctor and formerly the chief of urology at St. Elizabeth's Hospital, was 58 years old at the time of the police interview. Approximately 30 hours had passed between the defendant's admission to the hospital and when police interviewed him. Well, I mean, I don't know. We don't know what drugs they had him on, but I guess if he was on some major drugs like Haldol or something or anything, they would have pointed it out in their papers. The defense would have, because they have his medical records. Approximately 30 hours passed. Okay. Medical staff informed Detective Gonski at 8 a.m. the defendant was conscious and alert and that he had woken up at approximately 1 a.m. asking for water and acting normally approximately 16 hours prior to the interview. During the interview, the defendant was coherent, alert, and responsive to the officer's questions. At no point did the defendant complain of any pain or medical concerns. And here's a case, Commonwealth v. Richards from 2020, that says, although still under the influence of anesthesia, defendant's statements voluntary where questions were conversational in tone, defendant's answers were responsive, defendant took care to attempt to answer questions accurately, and where accuracy of answers could be objectively determined, they were accurate. And another case from 2019 where the defendant was in the hospital. It found that he voluntarily and knowingly waived his rights because he did not demonstrate confusion or otherwise acting irrationally while speaking with the police. The defendant attaches his medical records to his motion, but those records do not reflect his mental status or medical condition at the time of the interview, whereas the records of the next day do not suggest a serious medical concern. Footnote 6, which says the defendant was medically cleared and released into police custody the next day, May 17th, 2020, at 3:30 p.m. Although the defendant alleges that he was despondent and depressed at the time of the interview, such claims alone are insufficient to render his waiver of his Miranda rights invalid. There's a 2020 case in Massachusetts where they found the statements voluntary, where defendant, although he made suicidal statements throughout the interview, repeatedly provided police with coherent narrative of incident and no indication he was acting irrationally. Another case where the defendant was suicidal. Another case, even if defendant was depressed at the time of the confession, this does not render waiver of Miranda rights involuntary, where the defendant had no prior history of psychiatric treatment, was cooperative, responsive, maintained good eye contact. For the statements to be admissible at trial, the Commonwealth must prove under reasonable doubt that the defendant's statements to the police were voluntary. Similar to the determination of whether the defendant voluntarily and knowingly waived his Miranda rights, whether a statement was voluntarily made is consider in light of the totality of the circumstances, including the manner in which the interrogation is conducted, whether Miranda warnings were given, the defendant's physical and mental condition, and the defendant's individual characteristics, age, education, intelligence, emotional stability, and experience with the criminal justice system. They're going to go on with a lot of case law here. I'll scroll through this slowly in case you would like to read it later. You can always pause on the page and read that all for yourself. The defendant was not handcuffed and only 2 officers were present at all times during the interview. And they go on, talk about the tone again. It's a little bit repetitive. At no point did police exaggerate the strength of the evidence or make any promises or assurances of leniency. Though distraught and upset at times, the defendant was alert, oriented, lucid, and appropriately responded to the officer's questions throughout the interview. Many of the defendant's statements were self-serving attempts to try and justify his action. The defendant emphasized throughout the interview that the victim was volatile and began many of their arguments in their relationship. Okay, we're getting a little more information about what he said. And that the victim filed a restraining order and brought criminal charges against the defendant because she was angry that he was divorcing her. These are his words. When discussing the night that the victim was killed, the defendant attempted to minimize culpability by telling police that the victim was really aggressive, talking towards me about being angry about stuff, and that he choked her as a reaction to that aggressive situation. You're going to try and say there's no premeditation. Such self-serving statements support a rational intellect and voluntariness. After the defendant acknowledged that he thought he grabbed the victim around the neck, the defendant requested to take a break, left the conference room for approximately 43 minutes, and then chose to return to the conference room and continue the interview. It was at this point, after this break, that the defendant confessed to strangling the victim, provided officers a detailed account of what occurred that evening, and directed officers to the location of the victim's body, which he had submerged in a pond near a vacant house. I mean, it's worth pointing out here again, I didn't already say this today, that Dr. Turk had attorneys on speed dial. He had an attorney that represented him in his federal case for his fraudulent medical billing, I would imagine, because they got him a deal. He had an attorney from the divorce proceedings that he had initiated, that he was in the middle of, with Katie. He had multiple lawyers. Why he gave a statement, I'll never know. Always, always, always ask for an attorney, especially if you're innocent. Considering the nature of the interview, the tone, demeanor, blah, 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 blah. That's all the reasons they think it's voluntary. And then they go on to say that presented with an emergency, including serious harm and potential loss of life, the police officer's warrantless entry into the Dover family residence and the defendant's hotel room was justified under the circumstances. The emergency aid exception permits the police to enter a home without a warrant in order to provide emergency assistance or aid. Well, remember all those people squawking out there on the cesspool about how there's no reason that 34 Fairview had to be searched because they didn't have a warrant, and there's no way they could have gotten a warrant, and there's no probable cause to go in that house. Well, I'm going to submit to you that they didn't know what they probably knew because somebody told them, but how did they know that nobody inside the house was killed? I mean, when they pulled up on that scene, right? According to the testimony of the witnesses in the trial, Jennifer McCabe and Carrie Roberts said it was snowing so hard they couldn't see. They couldn't see John O'Keefe's body, but Karen knew exactly where it was and then screamed, "Stop the ducking car!" and ran out of the car and ran right to the body. And it was there were such blizzard conditions going on that Jen McCabe and Carrie Roberts didn't see the body. How could she see the body unless she knew where he was because she hit him and she's guilty? How did Jennifer McCabe not know? Let me rephrase. How could Jennifer McCabe know the cause of death when she called 911 and said, "There's a man passed out in the snow. Come to 34 Fairview"? What if he was shot? What if there was an intruder? That was her sister's house. Her sister and brother-in-law and their children lived in that house. How did she not run into that house? Because remember, no phone calls to Nicole, Coco, or Uncle Brian A. till after the 911 call. How come she didn't run into the house to make sure nobody in the house was killed? Right? Paul Jenkins says, "I agree. How do they not know the people in the house were not dead?" Yep. I will never understand how a dead man on a lawn is not probable cause. Could there have been an emergency aid exception? I don't know. Not a police officer. For a warrantless entry to fall within the emergency aid exception, there must be, at the time of entry, an objectively reasonable basis for the officers to believe that an emergency exists. And after the entry, the conduct of the officers must be reasonable under the circumstances. Well, according to, I think it was Paul O'Keefe's grand jury testimony, and don't quote me on this because I think he said it, but I'm just not exactly sure where or when, during one of the grand juries, that when he saw his brother in the hospital or his body, it looked like he had gone 10 rounds with Mike Tyson. If it looked like he had been beaten to death or bludgeoned to death, how did they not know that there was some kind of maybe maniac running around the neighborhood, killing people? I don't know. Officers do not need ironclad proof of a likely serious life-threatening injury. It is enough that there are objectively reasonable grounds to believe that emergency aid might be needed. I have another question. After Jen McCabe calls 911, and then there's 2 calls that she says were butt dials to her sister Nicole, or she deleted them or something. Did Jen McCabe talk to the officers? Did she tell any of the officers, oh, you don't need to go inside. Don't worry. I just talked to my sister. Everything's good. Is that a possibility? Were any of the officers asked that? Because there's a lot of body cam and dash cam footage, dash cam footage of Jennifer McCabe talking to a lot of the police officers who were first on the scene from Canton. Right? Did she tell any of them, "Oh, don't worry, I called my sister. They're good. Nobody's hurt inside"? Because, I don't know, it just seems like I've talked to the Las Vegas cops about this, and they believe absolutely 100% they should have went in the house to make sure everyone was okay. And it says here, according to Massachusetts law, police do not need to probable cause to believe that a crime had been committed. Where the occupant of a home has reliably been reported missing, well, that's not in that case, but in this case, the exigency that justifies entry into the home is the immediate need for aid to prevent physical harm, regardless whether the feared harm arose from a criminal act. The reasonableness of the entry is evaluated under the totality of the circumstances. The Commonwealth bears the burden in demonstrating that a warrantless entry and search fits within the emergency aid exception to the warrant requirement. Cusco says, Jen McCabe claimed that law enforcement asked her to go in the house and wake up her sister. Mm-hmm. That's right. Dan says they didn't even knock on the door and investigate if everyone in the home was okay. Nope. Law Junkie said the same thing. My husband said the same thing. He could enter a home without a warrant if he thinks someone's in danger or being seriously injured. Stephanie says exigent circumstances would have allowed the police to go into 34 Fairview. It's a good time to remind everyone to smash the like button and share the stream out, because so many people don't know about this case, and I think they need to. Thank you kindly. Also, if you wouldn't mind, and you're here and you do not subscribe to my channel, you can hit the subscriber button below. You might have to close out the chat if you're on your phone and just hit subscribe. And if you can't find it there, it's in the show notes. And I'm on a personal quest to, number one, beat Vinnie Politan in subscriber count on his personal YouTube channel. We're getting there. I think, I don't know how many we are away right now. And also, I want to bust up 75,000 right now. It's 74,444. I got to look at, I have a book right here of angel numbers. I'll look up 444 later to find out what that means, because I'm sure it has significance. We're at 74,444. So if you would help me in my personal quest, it'd be such a nice thing for you to do today. Thank you. Appreciate you. 74,444. Okay, now I'm curious. Zoe says, because Officer John O'Keefe wasn't a resident of that home, there wasn't probable cause to enter. However, common sense would be to knock on the door and inquire if residents are home, alive, and if they heard or saw anything. Well, they did go in the house eventually after John O'Keefe's body was taken away. And they say, one of them says they didn't leave the foyer. The other one says they went into the kitchen or the dining room table or something. But this is the first time I ever thought of the fact that Jennifer McCabe may have told someone, I called my sister, everything's fine in there. And that's why they didn't do it. But I don't know that any of the officers were ever asked that. But we do know Jennifer McCabe denies talking to her sister in, I think the phone calls were something like maybe 7 and 8 seconds. And then there was a call and a deletion to Uncle Brian A., I believe. It's the first time that ever popped into my head. All right, moving on. Where the occupant of a home has reliably been reported missing, the exigency that justifies entry into the home is the immediate need for aid to prevent physical harm, regardless whether the feared harm arose from a criminal act. Commonwealth bears the burden in demonstrating a warrantless entry, and search fits within the emergency aid exception to the warrant requirement. Police entry into the defendant's hotel room. Police had an objectively reasonable basis to enter the defendant's hotel room of the Residence Inn in Dedham on the morning of May 15th, 2020. The hotel manager had previously entered the defendant's room that morning in response to the victim's ex-husband arriving and raising concerns about the health and well-being of the victim. Upon entering the room, the manager observed the defendant lying on the bed, unresponsive, and saw bloody tissues on the counter. The manager did not see a female in the room, despite knowing that a female, the victim, was staying with the defendant. The hotel manager called 911 and reported these observations to the 911 dispatcher, as well as responding officers. Based on the manager's observations, which were conveyed to police, the responding officers had an objectively reasonable basis to enter the defendant's hotel room in order to administer emergency aid to the defendant. I mean, I do agree with that argument. But now I have questions, because the kids heard thumping, they heard them arguing, they see these black streaks, and now both cars are at the Residence Inn. 444 means surrounded by angels, says Vesper. Oh, that's awesome. So How did the other car get over there? But then the kids also said, I think that they hadn't seen his car ever. So maybe she took him and brought him over there, and then he drove her car back. At what point did he have her body in the car? I have questions. McAlpers investigated themselves and found no evidence of wrongdoing, says Frank Fax. Fax, Frank. Our Mick became a new member, and the Goodmans are here. The Goodmans gifted a membership. Thank you, Goodmans. After entering the hotel room, the responding officer's conduct was objectively reasonable and appropriate under the circumstances. In their search of the defendant's hotel room, as their search of the hotel room was limited to administering emergency aid to the defendant by identifying a possible cause for his condition and locating the victim. When the officers entered the room, they observed the defendant lying on the bed, unresponsive, but with his eyes open and occasionally moaning. The defendant had wrist lacerations consistent with self-harm and cuts on his arms and legs consistent with scratches from brush. Well, it's so interesting that they made the connection that the scratches on his arms and legs were consistent with scratches from brush or bramble. But they had no idea what caused those lacerations to John O'Keefe's right arm, except for what? An exploding taillight. And also, as Reddington points out, he was wearing jeans. Harry was, when they came in and found him on the bed. So how did they even see any scratches on his legs? And I also will submit to you that if he really wanted to take his own life, he would have. Because he's a surgeon. He would know how to do it quickly. The defendant did not move when police entered the room. Police attempted to wake the defendant, but he remained unresponsive. An ambulance was dispatched. Aware that a female had been staying with the defendant and that her vehicle was parked outside, police looked around the room for this woman. She was not there. On a small table in plain view, police observed a large kitchen knife with what appeared to be blood on the blade and several tissues with blood on them. There was a half-empty bottle of Glenlivet scotch by the bed. Well, we had Jameson, which I think is whiskey, right? I don't do brown liquors. And we have Glenlivet. We had Jameson in the Karen Reed trial and Glenlivet in Harry's trial. Based on the defendant's conditions and the officer's experience and knowledge, officers suspected the defendant had ingested a substance other than alcohol. Searching for a possible cause for the defendant's condition, investigators discovered a loaded syringe under the defendant's mattress. In the Commonwealth versus McCarthy, the court found objectively reasonable for police to search handbag with reasonable belief woman was suffering from drug overdose. EMS administered Narcan to the defendant, and he was transported to Norwood Hospital. Police observations and search of the hotel room was objectively reasonable and limited to administering aid to the defendant. Moreover, where police were aware that the victim's car was parked at the hotel, she was not answering her phone, had left her children at home, which was very unusual, and believing the ex-husband had received a disturbing text message, police had an objectively reasonable basis to look through the room in order to potentially locate the victim for whom they had an objectively reasonable belief could be harmed. And that text message is in the footnote. We already read it. Section B is police first entry into family residence at 29 Valley Road. You know I got to Google this house so we can look at it later. Hold on. Well, just because we're here. 29 Valley Road in Dover is a 5,380 square foot residence with 4 bedrooms and 6 baths. And let's see. Last time it was on the market. It sold in May of 2021, 1 year after the murder, for $1.7 million. It was purchased September of 2017. Must have been when Harry purchased it for $1.625. Police had an objectively reasonable basis to enter the defendant's and victim's residence at 29 Valley Road. At the time Dover police were dispatched to the family residence at 29 Valley Road, police were aware of the defendant's medical condition, that the victim's whereabouts were still unknown and nobody had heard from her since 1 a.m. the night prior. The victim's vehicle was located at the residence inn, that the victim's cell phone was pinging in the woods, not far from the family's residence. It was incredibly unusual for her to leave her children at home and not to answer her cell phone. The defendant had sent a disturbing text message about the victim to a family friend, the DV history between the victim and the defendant, and the pending charges of strangulation and assault and battery. The history of strangulation. When Dover police arrived at the residence at approximately 12:18 p.m., the victim's ex-husband was leaving the family residence with his and the victim's 3 children. Told Dover police he was concerned that the victim was injured and locked inside a bedroom within the residence. Again, why didn't he bang the door down? No shade, Steve Roca, but I mean, would you guys? And this is repetitive again. All of the things and stuff that we read before. It says here, when the police entered the residence through the open garage door, police briefly walked through the first floor and looked in each bedroom. When police reached the locked master bedroom, police forced entry with a Halligan bar. Police did not locate the victim during this protective sweep. This sweep took approximately 5 to 10 minutes. Footnote 8 says police did not search the basement. I mean, come on, man. Remember Jean Benet? Jean Benet was found in the basement by her father because they told him to go look down there. I don't know. We got to talk about that case one of these days. As you know, I have strong ties to Boulder. And the Boulder Police Department screwed that up from the beginning. Police exited the residence and continued to search for the victim. Where the officers' actions and search of the residence was limited to locating the victim, their actions upon THERE actions upon entering the residence was objectively reasonable under the circumstances. And these are the Commonwealth papers. C, police second entry into the residence at the family residence at 29 Valley Road. Thanks, Wendy DeB. Wendy DeB coming in with the 5. Wants to know, curious, Karen's phone was recording during Jen McCabe's 911 call. It would have been recording when they pulled up to 34 Fairview. What was said? I don't know. That recording is out there somewhere. I just don't know how to access it right now. If anybody's in the chat who can recall. Yeah. Thank you for the super chat. Why are they just skipping an entire floor? Says, oh, sweetie, no. Team Brittany says, thank you for the super chat, Wendy. Karen was calling Officer John O'Keefe over and over. She dropped the phone when she saw him in the yard. The phone kept recording. Yeah, so I guess what she's asking, though, Wendy's asking is, was there any conversation going on in the car among, like, Carrie and Jen? I think she yelled something like, open the ducking door or something. Hi, Jennifer. Says the Valley Roadhouse was sold off MLS for less than it would have been worth. Probably for attorney's fees. Just would be my guess. Thanks, Virginia Little, for stopping by to push the like and say hi. I'll allow it. Yes, little B, he admits it. He admits it, but he's trying to get all of his statements thrown out, saying that he didn't voluntarily waive his Miranda rights because he was literally comatose, according to the court papers by the defense. But this motion was made back in 2021. So we're just catching up. And by catching up and reading these papers, we get a lot more information about what happened that day. Ann Weber, I'd love to find that 911 call stream. Was it microdots? Team Brittany says the Glare has the entire call on his channel. Finding it in a deep dive might be hard, but yeah, it's there. KPT reminds us that the recording starts with Jen saying something like, "We're outside." After the first entry of the residence, police continued to ping the victim's cell phone, which showed several locations around Walpole Street at Cedar Hill. Well, isn't that so interesting? That they eventually find the phone in the purse in her bedroom, and yet when they're pinging it and trying to find it and her, they're getting several different locations. It just goes to show how the pinging might not be so accurate. I don't know. Food for thought. Police did not locate the victim at these locations. At approximately 2:45 p.m., the victim's phone pinged near Medfield, but with a radius that included the Dover family residence at 29 Valley Road. Dover and Medfield police went to the residence again with a canine so they could search the area around the residence with the canine and determine whether the victim had left the residence and walked toward the Rocky Woods reservation. The officers present were different from those that entered the family residence earlier that day. Officers entered the residence in order to confirm whether the victim was inside. These officers were not aware that Dover police had previously entered the residence. What? How could that even be? That is like, that strains credulity. Really? These officers who went there to execute the search warrant were not aware that Dover police had previously entered the residence? I'm not buying that for one ducking second. Are you? Yeah, the bedroom door was locked and no one was in it. Right. That's interesting too. Kyron says. Huh. Upon entering the residence, police observed the master bedroom door was broken. Well, at that point, did you realize they banged the door down with the Halligan bar? Pinging isn't as accurate as GPS, doesn't triangulate. Huh. So there's that, says nothing surprises me. I guess I should feel that way. I guess I should feel that way too, except every time I read something new, sometimes it just outrages me. It's like a renewed outrage. Sergeant Colby Roy took out his firearm and entered the master bedroom with the other officers. In the bedroom, they have observed broken glass on the bed and blood on the bedspread. Sergeant Roy called dispatch and requested that they call the victim's cell phone. The phone rang within a purse in the bedroom. The officers photographed the phone in its location and exited the room. Once again, they know how to photograph evidence in its location where they find it. The officers photographed the phone in its location and exited the room. Did they take the phone with them? As the officers exited the residence, they observed black markings on the floor leading from the master bedroom to the garage. All right, when we look at the Zillow listing, which I have, we'll find out if the master is on the first floor. But I thought the daughter said she was down. I don't know. She heard them downstairs. I don't know. We'll figure it out. The residence was secured in anticipation of the execution of a search warrant. I often think aloud with you and brainstorm aloud. Where the victim was still missing and her phone was pinging near the residence, police had a reasonable basis to enter the residence a second time to confirm whether the victim was present and in need of emergency aid. While the individual officers may not have been aware that police had previously entered the home, the question is whether there was an objectively reasonable basis to believe that someone may be in need of assistance within the home. Police had an objectively reasonable basis to enter the residence a second time, where the victim remained missing under the highly concerning circumstances previously recounted, and the initial sweep of the residence was brief, such that it was possible the victim was located in a portion of the residence that police did not previously search, i.e. the basement. Police observations of the black markings, blood on the bedspread, and broken glass were in plain view and within the scope of the warrantless search. Okay, so the second search was also warrantless. The search for the victim's cell phone was also permissible, as police observed evidence of an altercation in the bedroom and believed the victim had been injured there. Locating the cellular phone within the bedroom would notify police that the continued pinging of the victim's cellular phone would be unproductive, and another search strategy would be required. Another search strategy. They have search strategies? Hiccups, 1 second. Pesky hiccups. Jennifer says the bedroom was on the second floor over the garage up to the left when she went up the stairs. So those marks that they found were on the stairs, because I thought they kind of said they were on the floor. Thank you. Therefore, the officer's second entry into the family residence was justified under the emergency aid exception. Footnote 9, while the officer's entry and search of the family residence was objectively reasonable and justified under the emergency aid exception, the officer's observations of the cell phone, blood, broken glass, and black marks would also be admissible pursuant to the independent source doctrine. Quoting Commonwealth v. Pearson. While the officer's entry and search of the family residence was objectively reasonable and justified under the emergency aid exception, the officer's observations of the cell phone, blood, broken glass, and black marks are also admissible pursuant to the independent source doctrine. You know what I really want to know? When they collected the pieces of the broken glass, did they put them in solo cups? When they collected the blood evidence from the bed or the bedding, did they throw the bedding on the floor and let it sit in the back of somebody's cruiser for 6 weeks? Is there a chain of custody log on such things as Katie's cell phone, the bedding on which the blood was found, the broken glass? Chain of custody logs on any of those things? Conclusion, the defendant's motion to suppress his statements made to police and other evidence should be denied, where the defendant voluntarily and knowingly waived his Miranda right, and his statements to police were made voluntarily, and police's warrantless entry into the defendant's hotel room and the Dover family residence were justified under the emergency aid exception. XOXO for the Commonwealth. Lisa Beatty, assistant DA out of Canton. Remember all those phone calls that Jen McCabe made to Tom Beatty? We talked about I don't know. Beatty's not a name that I see that often. Is Lisa Beatty the assistant district attorney in Norfolk County in any way related to Tom Beatty? Does anybody know? And Megan Monahan, who's also an assistant ADA out of Canton. It's dated November 17th, 2021. Go to the chat for un momento. Oh, we didn't do this yesterday. What we're going to do it. The motion in Lemonade to exclude any reference to the word popcorn. which is interesting. Go into the chat. Oh, Cat's Meow 420 gifted 5 memberships. Thank you so much. That is so very sweet and generous of you, Captain Cat's Meow 420. And to the 5 lucky recipients of memberships, welcome to Cupcake Nation. I have a sign somewhere in my room. It's behind me, I think now. I changed my background around, and I have 5 kids, so I've had this sign since I had 2 kids. It says, "You can't make everyone happy. You are not a cupcake." It's been my daily mantra for as long as I've been a mother, which is over 30 years. So, I have opinions. I'm going to share them with you. I'm not a neutral channel. I've never claimed to be a neutral channel. There is no law, rule, or regulation of YouTube that says that law tubers have to be neutral. I'm going to give you my opinions, whether you like it or not. And sometimes you're going to like my opinions and where I fall. Sometimes you're not. Sometimes I'm for the prosecution. Sometimes I'm for the defense, but I'm always for the Constitution and the rules of procedure and the right to a fair trial. So I can't make everyone happy. And it kind of stuck. The cupcake thing stuck. You guys like it. You guys make me happy. Apparently I like you happy if you like me enough to want to join my membership. So it's a weird sort of throwback to the you can't make everyone happy, you're not a cupcake thing. Thanks, Wendy. We went over this, and Mama Z became a member. Welcome. Welcome. Yeah, Squirty Belly. We're going to get into that popcorn. We'll do popcorn first. Why don't we do popcorn first? Because that was the teaser. I don't know if this has been ruled on yet. Okay, because we're kind of skipping around in time, right? So here's the popcorn motion. And then I'm going to have to get back onto the docket and see if it was ruled on yet. This is the defendant's motion in limine to exclude reference to a code word popcorn. Now comes the defendant, Ingolf Tuerk, in the above captioned matter, and hereby moves this honorable court for an order precluding the government from eliciting testimony from either Vanessa Pettigrew or Kurt Pfannenstiel, who created a popcorn code word to use if Katie was in trouble. On the morning of May 15th, 2020, Kurt texted Vanessa and referenced a, quote, popcorn situation. They tried to call Katie, but were not successful. It is clearly not relevant that either witness's state of mind was pertinent to McLean's, quote, situation. They were friendly with both the defendant and McLean. And then footnote 1 says, it's important to note that Vanessa lied to police about the defendant's relationship with his ex-wife. Further, her husband, Vincent, tried to suggest that the defendant, quote, the German, was involved in a Boston murder. Oh, that's even more interesting. That Vanessa told her husband that the German was involved in a Boston murder? So sad. Code words for safety. Yeah. Yep. Team Brittany. Code words for safety. So there's that. Let me just take a quick look at the docket and see if that's been ruled on yet before they time me out on this dopey website. So that was paper number 75. That's filed in August of 2024. Talk amongst yourselves for a second. It's a lengthy docket, but not as lengthy as Karen Reed. Popcorn decision, anyone? Because this was supposed to be, this case was supposed to go to trial the last time on November 18th, 2024. That was adjourned due to the joint request of the parties, because that's when all these Proctor problems started percolating. Here's also something interesting. Oh, wait, affidavit in support. Popcorn, paper 75. Yeah, got it. Okay. I don't think it's been ruled on yet. And it was just, the case has been specially assigned as of November 6th to Judge Hallal. It was taken from Judge Cannone. So I guess the new judge is going to hear these motions in lemonade. I don't think it's been ruled on yet. There's a lot of really, really small font here. All right. If anybody knows any differently, let me know, but I just don't see anything about popcorn yet. Okay. So after this motion was made, there was an evidentiary hearing, go figure, in front of Judge Cannone. And that hearing was held, let's see, I think I took notes on this one. December 29th of 2021. And then 5 months later, Judge Cannone rendered her decision, which we will take a look at in a moment. Thank you. Thank you, Mazdad. Popcorn motion has been ruled on. It's a small font in that website, isn't it? Okay, one second. But before we do that, let's take a look at the, because, we like Zillow. Before we go to Judge Cannone's ruling, we can compare and contrast that with the decisions we've seen recently, like, for example, the one we saw allowing Dr. Russell to testify, but throwing some shade on her in the very last paragraph and giving the Commonwealth some not really necessary sort of praise, I guess. And her personal opinion, I don't know, it was such a weird decision, that Dr. Russell decision, in my opinion. All right, let's take a picture. Let's take a picture. Let's take a look. 29 Valley Road, which was the home of Dr. Ingolf Tuerk, Harry, and Katie. And for all the details of the post-nup, go back and watch show number 1. And the text messages and things. Lovely home. I hear that Dover's a wealthy community. It's from what I hear, from what you guys have told me. Lovely. Oh, look at the tray ceiling, the moldings. Not a fan of that color green, but some people might be. Looks like maybe a big dining room with a bay window. Beautiful cabinetry, very high end. Just lovely. But it's a murder house. Unfortunately, it's a murder house. I wonder if the current owners know, because apparently the 34 Fairview owners did not know the history behind 34 Fairview, and they're not happy that they're getting looky-loos and grief tourists coming by their house, creeping up on their lawn and their front porch and taking pictures. Nice 3-car garage, over 5,300 square feet. No pool. That's interesting. Big yard. how much property. Let's see how much property it is. Now I'm curious. Built in 2015. Oh, so he bought it in 2017. It was on 1 acre. The Zestimate right now is 2.323 million. And there are some other homes that are nearby that have sold recently for over 3 million. There's a lovely, lovely house right here. 5 bedrooms, 7 baths, 8,300 square feet, sold for 2.9. Beautiful. Guess what happens in Dover stays in Dover, because not a lot of people know about this case. And that's not really fair to the memory of Katie McLean, is it? Nope, it isn't. What are the property taxes in Dover? All right, so looks like Harry bought it in September of 2017 for 1.625. It was sold May of 2021, 1 year almost exactly to the day of the murder of Katie McLean, for 1.7. He didn't make much money, if any. Property taxes in 2024, 23,300 for 1 acre in Dover. It's like Long Island property taxes. You guys pay high taxes up there, huh? Interesting. So there's that. See if Ted Daniel has anything more to report to us on the goings on today with Trooper Michael Proctor, maybe soon to be ex-trooper or former Trooper Michael Proctor. We don't know. But it doesn't look like anything. Give me 1 second. I mean, people are saying it's ridiculous that this is closed door, but aren't all municipal proceedings that are administrative not open to the public? I mean, I'm not surprised by that at all. Actually, the guy who's even saying this is an attorney. So that doesn't surprise me. But SD got in there and said, thank you, Ted, for covering this. I appreciate the updates with some hearts and one of these emojis. Go, SD! We love SD. I don't think there's anything interesting. Somebody wants to know, have you seen any of his fellow troopers that had testified as witnesses? Nope. Not a whole lot of detail. If any of you find out anything, you can put it in the chat and hopefully I'll see it. It's hard for me to read the chat when I'm also reading to you, because I have to enlarge my screen to read to you, and then it kind of closes the chat. And Patriotic Addict says what we're all thinking. MSP will delay the final decision until after the Karen retrial. You might be right. That means that the bet that Scott and I have with regard to this, our $50 bet, is going to have to wait a while. Scott says all police hearings are closed to the public. Big Old Dog says lots of surgeons and execs in Dover. It's like Wellesley. Mastat said all municipal personnel matters are closed door and taxes on that property are approximately $8,000 a year. It just said $23,000. Is it a little wrong, or did our things cross? Because that's a lot less than it says, $23,000. Fun fact about California: prayers up for California. First of all, everyone in Pacific Palisades whose house is missing and gone and burned to the ground, and so many homes in Altadena, Pasadena. But in California, $8,000 a quarter. Okay. Oh, okay. Well, that's even more than 23. Property taxes in California are based on your purchase price of the home. So here in New York, we have assessments, which are bogus, and you can fight them like every 2 years or something. But in California, property taxes are based on the price that you pay for the home. Oh, Lisa, thank you so much for the Venmo, who says, to my favorite YouTube channel creator, listen on my commute to and from work and errands. End up sitting in parking lots listening, never getting my errands done. Need to get earbuds. Attorney wannabe. Oh, that's Attorney wannabe. Thank you so much for your $20 Venmo. Venmo is a great way to support creators because YouTube takes 30% of all super chats. And thank you so much. I appreciate you so very much. And yeah, you got to get some earbuds, or at least get some wired headphones so you can just put your phone in your pocket and you can still listen when you're shopping, because I do that. I'm always in the supermarket. I'm always in the supermarket with my earbuds in, listening to something or other. Usually a YouTube show. Because after you get sucked into the YouTube, You rarely go back to regular TV. Am I right? Am I right, friends? Am I right? Let us now take a look at Judge Cannone's 23-page decision in the Turk case. So we may skim it a bit, but 23-page decision. I mean, have we seen any 23-page decisions from Judge Cannone in the Karen Read case? So many decisions that we've seen have just been handwritten notations on the bottom of motion papers. Right? All right, here we go. Here's the decision, because I know you're waiting with bated breath. Feel free to point out anything, any thoughts, comments, concerns that you have about this. How many pages did I say it was? 23 pages decision from Judge Cannone? As I enlarge the font and read to you in my finest ASMR voice. Memorandum of Decision and Order on Defendant's Motion to Suppress Statements and Physical Evidence. The defendant, Ingolf Tuerk, is charged with first-degree murder of his wife under General Law 265, Section 1, which, as I pointed out to you before, carries a maximum penalty of life in prison. Yes, the handwritten notation thing is uniform across the Commonwealth. Right, so sometimes they do that, right? If it's just like granted, right? If it's nothing huge, but in this case, for this motion, there's a 20-something page decision. He moves to suppress statements that he made to police while in the hospital and items seized without a warrant from his home and hotel room. On December 29th, 2021, the court conducted an evidentiary hearing on the motion. After a hearing and review of all relevant documents submitted, the defendant's motion to suppress is denied. 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 Are you shocked? Let's see. In her findings of fact, we're going to skim a little bit. May 15th, she talks about the search of the Residence Inn. On May 15th, Dedham police received a call from the Residence Inn because Steve Roca couldn't find her. He was worried. Again, how did Steve know that she was at the Residence Inn? Maybe he knew. Maybe he knew that Harry was there. Kiki Kazoo is not shocked. So he asked the clerk to check on her. The clerk went in the room, did not see a female, male, all that stuff. Officers entered the room, found the male in bed. We read all this before. Let's see if she is accurate here. They checked the room for the female by looking at the kitchen to the right and the bathroom behind the bedroom, but didn't see anyone. Officer Ellis saw a knife on the table that appeared to have blood on it. There were pills on a table, cell phone, bottle of scotch was empty in the bed. Oh, she says it was in the bed, but they said it was on the nightstand. EMTs arrived and transferred the man to a stretcher. Officer Katie lifted the mattress to determine what may have caused the defendant's physical condition, and he found a syringe. The EMTs gave the man Narcan, which did not appear to have any effect on him. Officer Ellis noticed that the defendant had a cut on his forehead and that his legs were scratched. All right, so he had a cut on his forehead. That could be from him getting hit with the glass, right? Maybe the kids knew where Harry was staying. Okay, thank you. Thanks, Amy. Was the bottle empty or half empty? That's right. They said it was half empty. All the other papers said half empty. And now, according to Judge Cannone, it's empty. It's kind of an important detail. I don't know. Officer Ellis contacted Detective Gonski, who met him outside the hotel. While in the parking lot, they spoke to Roca, got that crazy text from the mutual friend. He tried to contact Katie, couldn't reach her, contacted the police. Roca did not know where Ms. McLean was, but only that she did not return to the home she shared with her children and the defendant the night before. Okay, wait a second. So he says when he couldn't reach her, he contacted the police. Who contacted the manager, the hotel manager? I thought it was him that contacted the hotel manager. I'm confused. Mr. Roca did not know where she was, but only that she did not return to the home she shared with her children and the defendant the night before. Well, remember they had an evidentiary hearing on this, so they might have called witnesses. So some of these details might be from the witnesses. Of course, it wasn't televised, I don't think. If anybody knows if it was televised, we can watch it. Send me the link. Fanbase at mlittlelaw.com. Mr. Roca informed the police that there was a history of DV between the victim and the defendant. After speaking with Roca, the officers returned to the hotel room. They searched the room for evidence and took photographs. Imagine, they took photographs. They did not have a search warrant, according to Judge Bev. Police seized a cell phone and the knife and brought it back to the station where it was logged into evidence. It was logged into evidence? What? Remember, that was Turk's. That was Harry's phone. Not Katie's phone, Harry's phone. Right? Unless Katie had a burner. I don't know. No, I mean, it had to be Harry's because Katie's was in the house. When back at the station, Detective Gonski requested a pinging of the victim's phone. K9 was brought to search the hotel to try and locate the phone and the victim. While at the station, Detective Gonski received a call from victim's sister, Beth. Beth told her that there had been a history of DV, which also involved recent criminal charges and a restraining order. This footnote is just repeating that text message and says that the text message was in Kikowski's search warrant affidavit. Beth told the detective that the defendant had fled to Florida Beth told the detective that the defendant had fled to Florida, but recently returned, and she believed at this point that he had killed her sister. On May 15, 2020, in the middle to late afternoon, Dedham police were joined by officers from the Dover Police Department, Medfield Police Department, and the Massachusetts State Police. Officers began canvassing the area of the Dover home owned by the defendant, where he lived with his wife, the victim, and her children. I don't see anything about the CERT team here. They spoke to neighbors regarding surveillance cameras. What? They spoke to neighbors regarding surveillance cameras. Let me say that again. They spoke to neighbors regarding surveillance cameras. The only neighbors, apparently, allegedly, maybe, that they spoke to around 34 Fairview was the deputy. Was he the deputy chief of police at Canton at the time? Tom Kelleher, who lived diagonally across the street from 34. And he said, yeah, my ring footage doesn't show anything interesting. And that was it. That was it. Even though his cameras are pointed directly at where maybe Officer O'Keefe's body was found. They spoke to neighbors regarding surveillance cameras. A K9 was brought to the hotel and to the property in Dover. Search of 29 Valley Road in Dover. May 15, 2020, at approximately 12:20 p.m., Dover Police Sergeant Todd Wilcox received a call from the Dedham Police seeking a well-being check on the wife of a man found unresponsive at the Residence Inn. Sergeant Wilcox was familiar with the defendant and the victim and was aware of the DV charges against the defendant. How did Sergeant Wilcox know them? Did they make calls to the house prior? I don't know. Was there a connection? Sergeant Wilcox, another officer, and the chief of the department arrived at 29 Valley Road. The ex-husband of the victim, Mr. Roca, was standing in the driveway with his and the victim's children, who reported that they had not heard from the victim. They were concerned because the master bedroom door was locked. At that point, officers made entry into the home through the open garage. Officers noted that there were no signs of violence in the kitchen, and at that point, there was no concern that foul play was involved. They went directly to the master bedroom on the second floor and announced their presence. The door was locked, and they forced it open with a Halligan. There was no one in the bedroom, and police did not notice any broken glass or other signs of violence. Well, so they didn't notice it the first time they went? After they banged the door down? The victim's pocketbook and cell phone were in the bedroom. They went inside the other rooms of the house to see if the victim was there. They didn't check the basement. They were only in the home for a few minutes. Why do they keep pointing out that they didn't check the basement? And why didn't they see the blood on the bed and the broken glass? Are they incompetent too? Because if I was the defense attorney, I'd be like, okay, wait a second. So when did somebody plant that stuff in the room? I mean, listen, it's a theory. How do the first police officers who banged the door down not see blood on the bed, a broken glass, but they see the purse? They notice the purse in the closet that has the phone in it, but they don't know that I don't know. I have questions. Huh. The victim's pocketbook and cell phone were in the bedroom, but they didn't get that until I thought later when they called it. Well, remember, this is the judge's decision, so who knows if it's accurate. Was the glass later planted? Right. They didn't have a leaf blower, says Mike. They were only in the home for a few minutes. Okay. But wouldn't blood on the bed be an important detail? And a broken glass be an important detail? I mean, Wildlight Arts says they've literally seen authorities and professionals avert their eyes in Massachusetts. Can't make this stuff up. It's inconceivable and ridiculous. Look at Kyron, 63 says, my gut feeling is to investigate the ex-husband. Should have been blood in the vehicle. I don't know. No black drag marks. Somebody's saying maybe they were just looking for her, and so they didn't know. I mean, I don't know. If you're looking for her and you can't find, wouldn't that indicate to you that something maybe violent happened? And she just did take off on her. I don't know. Later that afternoon, Officer Colby Roy of the Medfield Police Department learned that fellow officers were searching for a missing person in Medfield near the Rocky Woods Reservation, a 400 to 500 acre woods, because the victim's phone had been pinged to within 2,500 meters of the property on Hartford Street. The canine officer was called. Officer Roy thought it made sense to go check the victim's residence in Dover first because it was within the circumference of the ping. He and 3 other officers, including the canine officer, went to the property at 29 Valley Road. They took the dog from the house to the woods line to see if anyone had walked into the woods, and the dog did not alert to anything. The phone ping was still coming from the scene within 2,500 meters. Not knowing that Dover police had already searched the residence, Sergeant Roy decided that they should enter the home to look for the missing female. Again, how did they not know? Well, because he's with Medfield. And the Dover police, were they not communicating? Amy says, because they were looking for a person, not evidence. Children already checked the house for mom. That's why no basement. But again, he confessed, so. And this motion was denied, so that confession and that audio tape is coming in. Police entered the home and noticed that the kitchen was not in disarray. They went to the second floor. They noticed the door at the end of the hall, which was the master bedroom that had previously been forced open by the Dover police, contained splintered wood was partially broken open. Roy pulled out his firearm, and another officer pulled out his taser, and they approached the room. Upon entering and finding that there was no one in there, Roy noticed a pocketbook on the bureau. He noted that the bedding was on the floor and that the room was in disarray, including broken glass. All right, so the bedding is on the floor. He noted the bedding was on the floor. He called the station and asked for dispatch to call the victim's cell phone. At that time, they realized the phone was inside the purse. Pocketbook on the bureau. Was it on the bureau? Didn't they say closet before? I don't know. A lot of inconsistencies. Officers left the building and learned the Dover police had been there earlier. So they didn't take the phone? State Police Trooper Jeffrey Kukowski, he was also involved in Karen Reed, or he was on the text chain of Proctor, something like that. Joined the investigation around 6 p.m. on May 15, 2020, when he went to Dover and worked with other officers canvassing the area. Again, there's no fatality yet. Why is MSP involved? Did they get involved in missing persons cases? I'm just curious. Interviewing potential witnesses. Look at that, doing interviews. Began writing up search warrants. After interviewing Mr. Roca, Vanessa Pettigrew, and Miss McLean's friend, Vanessa is Miss McLean's friend, and Kurt Pfannenstiel, Trooper Kukowski applied for search warrants for the defendant's home, 29 Valley Road, for room 228 at the Residence Inn, and for 2 motor vehicles, one belonging to the defendant and one belonging to Miss McLean, both parked at the Residence Inn. Search warrants contained information obtained through the interviews of Mr. Roca, Ms. Pettigrew, Mr. Pfannenstiel, as well as the victim's children. They were written after Kukowski had been fully informed by officers as to the course of the investigation at that point, including the fact that a cell phone, knife, syringe, gloves, scotch, and photographs had been seized from the hotel room. Photographs had been seized? Or they took photographs? I want to know what they seized photographs from the hotel room. Trooper Kukowski testified credibly before me, the gatekeeper, Justice Beverly Cannone, that it would be his practice to seek a search warrant in this investigation for the defendant's residence, the hotel room, and both vehicles, regardless of the observations from the police officer's previous entries. So now it's important to know what a trooper's practice is. What is his custom and practice? In addition to the items listed above, when police searched the defendant's home pursuant to the warrant, they seized 2 cell phones, a laptop, some paperwork, and they took swabs of some stains. Additionally, photographs were taken. Oh my God, photographs? I think they took some photographs at the crime scene of Officer John O'Keefe's dead body, but then they lost the camera or something. So there were very few photographs, maybe one photograph of a random piece of taillight in some location that could be anywhere because there were no measurements taken. What about the black drag marks? Yeah. Good point, Yuri's math teacher. Interview at Norwood Hospital. The defendant was brought to Norwood Hospital via ambulance. Upon arrival, he was in a comatose condition with a very high blood alcohol level. He recorded a score of 4 on the Glasgow coma scale. He had abrasions on both his arms and legs and several deep scratches on his left wrist, possibly consistent with self-harm. May 15, 2020 was the height of the C-19 panty, and protocol needed to be followed for people entering and leaving the hospital. Officers spoke with Alicia Wilkie, the director of safety for the hospital, in an attempt to get in to see the defendant. They were told that he was unresponsive. On May 16, 2020 at 8 a.m., officers received an update from Ms. Wilkie that the defendant had woken up at 1 a.m. asking for water and otherwise acting normally. Later that afternoon or early evening, officers reported to the hospital to question the defendant. When the officers got to the hospital, they did not inquire about the defendant's condition or whether he was taking any medication. Whether they gave him any. On May 16, 2020, Trooper Kukowski spoke with Ms. Wilkie to arrange entry into Norwood Hospital and to speak to the defendant. He was accompanied by Detective Richard Porro and Detective Gonski, who were all dressed in plain clothes. Only 2 officers were present in the hospital at a time. Ms. Wilkie told the defendant that the police were there to talk to him, and she escorted him to a family room located adjacent to the wing of the hospital where he was staying. The officers and the defendant sat in a socially distanced arrangement, and they all wore masks. The interview began at 5:19 p.m. Footnote 2, which says an audio recording and transcript of the interview were submitted as exhibits at the hearing on this motion, and that was in 2021. And the investigation was in 2020. And they have the capability, my friends, to audio record and make transcripts of witness statements, defendant statements, etc. Before it started, the defendant was given him his Miranda warnings and a Miranda waiver form, which he signed. The interview was recorded. It appears that the interview took over 3 hours. Wow, a 3-hour interview that is recorded during an investigation of a potential murder suspect. And at this point, they didn't have a body, and they still recorded it. Trooper Kikowski testified at the time of the interview he did not know what medications the defendant was taking, that the defendant had scored 4 on the Glasgow coma scale, or that the defendant was brutally intoxicated and had an extremely high blood alcohol level upon his arrival at the hospital the day before. At one point during the interview, the defendant asked for a break. He was allowed to leave, and he walked back to his room. He was gone for 43 minutes and returned to the family room in the company of hospital staff. When the defendant returned, he was not given Miranda warnings. After the 43-minute break, the defendant gave directions to the location of Ms. McLean's body. The directions were accurate. Trooper Kikowski testified credibly that at no time during the interview did the defendant appear intoxicated or to misunderstand what was going on. He testified the defendant gave police permission to take photographs. Photographs of him? Rulings of law. 1. Statements to police. The defendant first moves to suppress the statements he gave to the police during the interview on May 16, 2020 at Norwood Hospital. He contends that they were the result of a custodial interrogation and that he did not knowingly and voluntarily waive his rights under Miranda. In opposing the motion, the Commonwealth argues that the interview did not constitute custodial interrogation, and therefore, the police were not required to give the defendant a Miranda warning. Even if it was a custodial interrogation, the Commonwealth asserts that the defendant made a knowing, intelligent, and voluntary waiver of his Miranda rights. And then she's going to go on and talk about some law under Miranda and what constitutes being in custody. So here she talks about some case law. We're just going to FF it a little bit through this because it's 20-something pages long. And then she reasons, here, when the police questioning of the defendant began, it was not custodial. A hospital employee brought the defendant to an empty family room at the hospital, which they called a conference room in earlier pleadings, which was a neutral location. He was not handcuffed. He was interviewed by 2 officers. At the start of the interview, the officers did not communicate to the defendant their suspicion that he had harmed the victim. For approximately the first 30 minutes of the interview, the tone was informal and conversational. The defendant told the officers about his past relationship with the victim leading up to May 15, 2020, and the officers' responses to the defendant were sympathetic. However, about 30 minutes into the interview, the nature of the questioning changed. Although the tone of the interview remained calm and conversational, the police indicated to the defendant that he was the focus of the investigation. Trooper Kikowski told the defendant that he was there as a, quote, homicide detective to give the defendant an opportunity to tell his side of the story. The officers repeatedly questioned the defendant about what he did to the victim and where they could find her. See the transcript, which says, "Where did everything go down, Harry? Where did it happen? We need to know where you left her. We need to know how you left her, Harry. Is she fully clothed? We need you to tell us where she is so we can bring her home. A reasonable person being interrogated in such a manner would not feel free to end the interview and leave. The interview, therefore, evolved into a custodial interrogation, and the waiver of the defendant's Miranda rights he executed before the interrogation must have been valid for the statements to be admissible. All right, look at, she's going through the elements. She's going to explain her reasoning here. At first, it was not custodial, but then when the tone changed and they told him he was the focus and they started badgering him, where is she? Where is she? We need to find her. You need to help us bring her home. Then it was custodial, and so now she's going to determine whether or not his signed waiver of his Miranda rights is valid. And she says, to be valid, the waiver of Miranda rights must be made knowingly, intelligently, and voluntarily. The Commonwealth bears the burden of providing the validity of the waiver beyond a reasonable doubt in light of the totality of the circumstances. Relevant considerations include any promises or other inducements, conduct of the defendant's age, education, intelligence, and emotional stability, experience with and in the criminal justice system, physical and mental condition, the initiator of the discussion of a deal or leniency, whether the defendant or the police, and the details of the interrogation, including the recitation of Miranda warnings. The defendant here argues his Miranda waiver was invalid because he, quote, was in the hospital, was admitted in a virtually comatose condition, and was despondent and depressed. However, the interview occurred at 5:19 p.m. on May 16, 2020, over 24 hours since the defendant was admitted to the hospital and over 14 hours after the defendant had woken up and was described as acting normally by hospital personnel. Kurt says, Kurt Straub says, I'm siding with the Commonwealth on these points. I don't see any nonsense here. No. I think it's the right decision, but I also think we're learning a lot about investigations of the MSP prior to the murder of Officer John O'Keefe. They had the capability to audio record witness statements. They did a 3-hour interview of him. They've got a transcript of it. There's no indication his mental, emotional, and physical condition interfered with his ability to understand the circumstances, his Miranda rights, or the nature of the questioning. She was on to say at the time of the interview, he was 58 years old. He was a physician and formerly employed as chief of urology at St. Elizabeth's Hospital. The defendant was familiar with the criminal justice system, acknowledging during the interview that he had pending criminal charges against him for abusing the victim. Trooper Kikowski recited each of the defendant's Miranda rights, and he acknowledged his understanding of them and his decision to waive them and speak with the officers. I'm sure they have that all on tape, and he signed a waiver form. And then, in light of all these factors, Judge Cannone finds that the defendant voluntarily, knowingly, and intelligently waived his Miranda rights. Moving on. She says there's no question the defendant's statements to the police were voluntary. There were no circumstances during the interrogation which would result in the defendant's will being overborne. The tone of the interview was calm throughout. The defendant was not handcuffed, and only 2 officers were present during the interview, sitting socially distanced from the defendant. Oh my gosh, I would love to know. But we don't know because we don't have a recording of the interview that Proctor and Bukhenik did of Karen Reed when she was at her parents' house in Dighton. I'd love to know what the tone of that conversation was. Do you think it was calm throughout? They were socially distanced. There was only 2 of them. Defendant spoke clearly, was cooperative, had no trouble understanding the questions. Entered the hospital comatose and with a high blood alcohol level. What did they say? 0.226? I don't know how to do the extrapolation. And it was an ethanol. I don't think they did a BAC. It was an ethanol test, I think they said, right? At no point during the interview did the defendant appear incoherent or intoxicated or display any lack of understanding of the officer's questions. As noted, the defendant's age, education, and experience supported his understanding of the circumstances. The defendant made self-serving statements describing the victim as angry and aggressive and telling police that she was always ready for a fight and had hit him first. She was always ready for a fight and had hit him first. Well, here's a question. If Katie, let's say Katie had a gun in her nightstand drawer that was loaded, and this fight started, and she grabbed her gun and she killed him, would people have sympathy for her, or would they treat her the way that they were treating or treated and did treat and still treat Ashley Benefield in Florida? Question. I don't know. I'm just wondering. Ashley Benefield had also filed for several restraining orders against Doug Benefield. Ashley Benefield tried to get them to enforce the restraining orders against Doug Benefield, but that cop that testified in the Ashley Benefield trial thought she was annoying and a scotch, and she was calling him all the time, and she was annoying him. They were in some legal entanglements, and then they were going to reconcile. Similar situation, except Ashley Benefield had a baby to protect. And if Ashley Benefield didn't have a gun available to her, perhaps she would have wound up like Katie McLean. I don't know why everyone, not you guys, but so many people who watched the Ashley Benefield trial just thought that she was a liar. And that it didn't matter all the things that Doug had done before. Shooting the gun into the ceiling, punching the dog so hard he knocked him out, throwing the cat down the stairs, punching holes in the walls, shooting the gun off in the house to scare her. I don't know. Just wondering. This is a great point, Zoe, and I want to talk about this after I'm going to start this question, because it reminds me of what's going on in the Jennifer Crumbly case, which I also want to cover, but just not during this show. Depends on how the narrative is framed in the media. Jennifer Crumbly, her attorney, has discovered that the district attorney's office entered into a $100,000 contract with a PR firm to spin the narrative against the Crumbly parents. Same thing is going on in the Justin Baldoni, Blake Lively situation. There are accusations that a PR firm was hired by Justin Baldoni to enact or engage in a smear campaign against Blake Lively. They're calling it astroturfing, as opposed to grassroots movements where people are hired to go in. Bots are hired to spin the narrative on social media. Interesting. Talk about police corruption. Cammie watched a documentary on Netflix, Victim/Suspect. Was it good? Trooper Post Pirouette says, holy duck. Debbie says, what? Yeah, I'm going to do a show on that later, but it's one of the arguments for a new trial for Jennifer Crumbly. $100,000 the district attorney's office paid to a PR firm to spin the narrative, because remember, in Jennifer Crumbly's case, that was the first time that a parent had ever been tried for murder based on something a child had done. A horrific school shooting case. Horrific. Moving on to Judge Beverly Cannone's decision on this motion. Notably, the defendant took a 43-minute break before the interview. Then he came back, and then he gave, that's before he provided the police with the directions to the victim's body. He had the break. Therefore, That evidence demonstrates his mind was rational, his faculties were under control when he spoke to the police. Evidence seized from warrantless searches. The defendant challenges the warrantless entry and search of his hotel room and his home and moves to suppress all evidence derived from these searches, which we call the fruits of the poisonous tree. The Commonwealth asserts that its actions were justified under the emergency aid exception to the warrant requirement. Even if their actions were not justified under the emergency aid exception, the Commonwealth contends that the evidence should not be suppressed because under the independent source doctrine, the evidence would have been seized pursuant to the search warrants obtained for both the hotel room and the residence. Warrantless search of a home is presumptively unreasonable under both the Fourth Amendment to the U.S. Constitution and Article 14 of the Massachusetts Declaration of Rights, unless it falls into one of the few specifically established, well-delineated exceptions to the warrant requirement. The emergency aid doctrine establishes one such narrow exception to the warrant requirement. The emergency aid exception applies when law enforcement officers enter a dwelling to provide emergency assistance. To fall within this exception, the Commonwealth must demonstrate that there was an objectively reasonable basis for the officers to believe that an emergency existed at the time of the entry, and after the entry, the conduct of the officers was reasonable under the circumstances. Moving on a bit. The Commonwealth does not need to show that the officers had ironclad proof of a likely serious life-threatening injury. I mean, that's kind of like even more of an argument for why they shouldn't have gone in. Maybe they should have gone into 34 Fairview. Nor must the police have probable cause that a crime had been committed. It is sufficient where the totality of the circumstances demonstrates objectively reasonable grounds to believe that emergency assistance is needed to prevent imminent physical harm or to provide assistance to one who is injured or to protect life or in some circumstances property. Anonymous Canadian girl says, it seems that victims can only have credibility if they are unalived. Otherwise, we are often seen as hysterical, histrionic, borderline. Yep. Go on till she talks about the facts a little bit. Search of the hotel room. As to the officer's initial entry and search of the defendant's hotel room, the Commonwealth has demonstrated objectively reasonable grounds to believe that an emergency existed at the time of the entry. And the manager had already gone into the room, they say. Goes into the facts that we've already read, and she adopts them in her decision. After entering the hotel room, the officer's conduct was limited to seeing if the victim was in the room, providing assistance to the unresponsive defendant. Thus, objectively reasonable under the circumstances. The defendant challenges the police officer's conduct upon entering the room, arguing that once the EMTs arrived and placed the defendant on a stretcher, the officers had no reason to remain in the hotel room. The defendant contends the officer's actions after EMTs arrived amount to a general search for evidence of criminal activity. The court does not agree. After EMTs moved the defendant to the stretcher, Officer Katie lifted the mattress and found a syringe. The court credits testimony that his actions were in an effort to determine what may have caused the defendant's physical condition so he could receive medical aid. Such limited actions were objectively reasonable under the circumstances. I still want to know what was in the syringe. Have we found out what was in the syringe? However, the court agrees with the defendant that the second warrantless entry of the hotel room by Detective Gonski and the other officers was not objectively reasonable. The police returned to the hotel room to seize items and take photographs after EMTs transported the defendant to the hospital. At that time, the police could not have reasonably entered the hotel room to provide the defendant with emergency aid because he already had been taken to the hospital. Nor was there any objectively reasonable basis for the police to re-enter the hotel room under the emergency aid exception to search for Ms. McLean. At that point, the police were already aware that she was not in the room. Emergency aid exception does not permit entry for the purpose of gathering evidence to assist in a police investigation of a missing person. Although the second warrantless entry and search of the hotel was improper, the Commonwealth contends that the court should not suppress the challenged evidence because it is admissible pursuant to the independent source exception in the exclusionary rule. No, the independent source exception to the exclusionary rule. Specifically, the Commonwealth argues that the search warrant that police obtained for the hotel room did not refer or rely on any observations made by the police during the second entry of the hotel room. Therefore, the court should not suppress the evidence seized during this search, which would have been recovered during the execution of the warrant. The court is persuaded that the evidence would have been seized pursuant to an independent source. All right, so she's saying they had no right to enter the second time without a warrant, but because nothing that they alleged to have seen during the second search was talked about in the application for the search warrant that they eventually did get, it would have been seized anyway pursuant to an independent source. I don't know. Seems like it's probably the right decision. Because what did they find during the second search that they didn't find during the first search that was okay? I'm not sure. Anybody remember? They found the syringe during the first. The pills. It's the Commonwealth's burden to show by preponderance of the evidence that there was an independent source for the challenged evidence. The first prong of this test involves a subjective inquiry into whether the officer's decision to seek the warrant was prompted by what they had seen during the initial illegal entry. The court must assess the totality of the circumstances to ascertain whether the officer's stated reasons for seeking the warrant are implausible. She says here, although the search warrant for the hotel room was written after Kwiatkowski had been fully informed about the items seized during the second unlawful entry of the hotel room, Trooper Kwiatkowski testified credibly that he would have sought a warrant to search for evidence of what happened to the victim, regardless of the observations seen in the previous entries into the hotel room. The totality of the attendant circumstances supports this assertion. At the time Trooper Kwiatkowski started writing the warrant, the victim was still missing. They were aware of the abusive relationship. The defendant was with the victim the night before. He was staying at the hotel. The victim's car was at the hotel. Under these circumstances, it's not implausible that Trooper Kwiatkowski's decision to seek the search warrant was prompted by information learned during the interviews and investigate rather than any observations or evidence seized during the second illegal entry into the hotel room. And then here, the search warrant affidavit makes no reference to any observations or evidence observed on the second unlawful entry that were not observed by the Dedham police officers made in the initial lawful entry. So a whole lot of word salad here to say that all that evidence is coming in. Motion to suppress is denied. So there's any new information in here that we haven't read about between this stream and the last. They say the search of the home, clearly reasonable under the emergency aid exception. History of abuse and violence. The defendant had sent a text message about her to family. that her ex-husband was there, reporting that they were concerned. The master bedroom door was locked. So the police had an objectively reasonable basis for entering the residence. However, the police's second entry into the home by the Medfield police was not objectively reasonable. The information known to Medfield police was that a woman was missing in Medfield near the Rocky Woods Reservation, and her phone had been pinged within the area of her home. While ordinarily, under these circumstances, the police may have an objectively reasonable basis for entering the residence to see if the woman was there and in need of emergency aid, here, the Dover police had already done a sweep of the home and seen that the victim was not there. Medfield police should have known before their entry into the home, and therefore the court imputes the knowledge of the Dover police to the Medfield police and assesses their actions under the analysis of a second sweep under the emergency aid exception. And then in this footnote, it says the court notes that Sergeant Roy testified that a Dover police officer was with the Medfield police at the time of their entry, but relayed no information to them that a previous search had been done. Really? I mean, point me in the direction of any decision in the Karen Reed case that had this long written decision. I don't think, are there any decisions in the Karen Reed case that are 23 pages long? XOXO, Judge Beverly Cannone, May 11th, 2022. Despite the unlawful second entry into the home, the court will not suppress any evidence obtained as a result of that entry. Because of the panty? History of DV? And that's that. Yeah. Kurt Straub says, I'll agree the second search should have had a warrant. Why couldn't they have sealed the room and gotten a warrant? Well, that's the second prong. She says, after excluding all information obtained from the impermissible warrantless entry and search, the remaining portion of Kikowski's affidavit in support of the search warrant contained more than adequate information to support a finding of probable cause to search the home. The affidavit contains only one reference to observations from the second entry, noting that the officers returned to the residence at 29 Valley Road, searched the residence again, and found Ms. McLean's phone in her purse in the bedroom. But they didn't talk about the broken glass and the bloody bedding. The untainted information in the affidavit included, among other things, what police had learned from Mr. Pfannenstiel, Ms. Pettigrew, and Mr. Roca, including the contents of a text message sent by the defendant to Pfannenstiel, the history of DV, failed attempts by Ms. McLean's family and friends to contact her, the children's account from the night before, the hotel room. Police had searched numerous locations and called hospitals, had no information as to McLean's whereabouts. The affidavit concluded that due to the C-19 panty and that most people were not leaving their homes, combined with Ms. McLean leaving her children, it was a reasonable inference that she had left the residence in Dover by violence or against her will. Such information was more than enough for probable cause to search the Dover home for evidence of what happened to Ms. McLean. Therefore, XOXO, motion denied. Beverly J. Cannone. What say you, my friends? I think the next thing coming up, sorry, in this case is a February 12th conference. Maybe it'll be televised, maybe it won't. There are some motions in lemonade that we can continue to go over if all of you are still interested in following this case with me. And I hope that you are, because I am interested in seeing justice for Katie. I don't see any mitigating factors here. In fact, everything I see points to the fact that he had a lot of motive to take her life. Patriotic says, I think she wrote a 23-page decision so that her buddy, Attorney Reddington, wouldn't be mad about her denial of the motion. She seems to be a Reddington pleaser in all cases. Interesting. Everybody's interested. We're in. Free Billy Tibbetts. Free my boy, Billy Tibbetts. Free Billy Tibbetts. Free Billy Tibbetts. Phoebe says, no, because they didn't expect Karen Reed to go to trial. They had no idea what would happen in this case, so they behaved normally. What the duck wants to know, has Karen even gotten 23 pages in all of her decisions combined? That's a great point. How could we not, says KBT. This is crazy. We already know most of the characters. I know. Todd says, it seems to me like no one who claims to care for her did nothing to avoid this. I don't know about that. Yes, follow. Crime and passion did not come up yet, but let's look at the difference between first-degree murder and second-degree murder in Massachusetts. And for that, we will go to the statute because he's charged with first degree. First-degree murder in Massachusetts. Well, I know you like receipts, so let's pull it up. Murder committed with deliberately premeditated malice aforethought or with extreme atrocity or cruelty in the commission or attempted commission of a crime punishable with death or imprisonment for life is murder in the first degree. Wait, do you guys have the death penalty in Massachusetts? I didn't think you had the death penalty in Massachusetts. What? It's an old statute? I don't think so. This is masslegislature.gov. Murder which does not appear to be in the first degree is murder in the second degree. Petty treason shall be prosecuted and punished as murder. The degree of murder shall be found by the jury. I wish people are saying no. No death penalty. So why does he even say a crime punishable with death? Maybe if it's a federal crime, but this is the Massachusetts general laws. It's premeditated. All right. And here's the punishment for murder in the first degree. Except as provided in subsection B, any person who's found guilty of murder in the first degree shall be punished by imprisonment in the state prison or for life and shall not be eligible for parole. Life without parole. LWOP. So there's that. The only thing that I can think of is he's going to try like hell, Reddington, to get the jury to see this as second-degree murder, not premeditated, heat of passion, she provoked me kind of defense. I don't know that it's going to work. Let's go back and let me just check Twitter one more time and see if we got anything on Proctor. Nothing yet. I see nothing yet. Anybody else have any other information to the contrary before we wrap for today? Somebody said leave without pay. 5 minutes ago and nothing yet. Okay. Thanks, Iceman. Yeah, federal, because I think in the Sandra Birchmore case, I think Farwell is eligible for the death penalty, right? Because it is a federal murder that they're charging him with, murdering a witness, because guess what? The state decided not to pursue any charges against Farwell. Even still, the state of Massachusetts, the Commonwealth of Massachusetts has chosen to not prosecute Matthew Farwell for the horrific murder of Sandra Birchmore, whose virginity he took at her age 15 while she was in the Police Explorers program. He's a police officer, was in Stoughton, right? And his unborn child that she was pregnant with. So they're not doing that in state court in Massachusetts yet, if ever. When, if ever, will they pursue state charges against Matthew Farwell? Anyone? Anyone? For the unborn child and 23-year-old Sandra Birchmore, who did not take her own life. Thank you, Moon Goddess, for gifting a membership. Welcome to the new member. And Hope says, I love when you're on YouTube. Love watching your streams. Thank you. Thank you, Hope. I appreciate you. Thanks for being here for 8 months. I appreciate you. Let's see if we gained any subs. Hold on. What were we have before? 74,444. I guess everyone's already a subscriber on this stream, because we only gained 1 subscriber since I asked everyone to hit that subscribe button. That would be so nice, because we want to get 75,000. But I think probably everyone here is already a subscriber, because those of you who are following me from the Karen Reed case are also in Massachusetts and interested in this one. He's going to put a lot of divorce guys on the jury. Tell the tale. She set him up and he killed her after she hit him by accident, says Big Old Dog. Yep. Thank you, mods, for doing an amazing job today. Little Miss Red Velvet is also thanking you. Love you guys with all of my heart. Thank the moderators. Stay cool, stay kind, stay classy. I know you guys can do it. I know you can, because you are better than all those mean, horrible, vitriolic people out there on the cesspool of Twitter. Stay cool, stay kind, stay classy. We'll see what happens with Proctor later. I'll be ready to go live if something does break on him. And I have some questions for you. Have you guys heard of, all right. Have you heard of Lily Jones and Bonnie Blue? And if you haven't, and you don't know what I'm talking about, maybe don't Google it. I am just outraged by this whole situation. Anybody? Lily Jones and Bonnie Blue. Anybody know about these people? Yes. I feel like we need to talk about this. I feel like this is a tragedy of horrific proportions about our children and what our children are seeing on the cesspool of Lily Jones is an OnlyFans person who decided that she was going to have 100 men in one day. She's in London. She did it. There's a documentary about it on YouTube. There's a guy who filmed a documentary. Her next conquest was going to be to try and have 1,000 men in one day, except this other girl, Bonnie Blue, who's 25 years old and also an OnlyFans model, did it the other day. Went past 1,000, up to 1,057. So disturbing on so many levels. Why? Why? Help me understand. Maybe that'll be the stream. Help me understand. Help me understand how these girls are going to live with themselves in the future. How Lily Jones's mother is like her financial manager and is supporting this. She's 23. How they're not going to have PTSD for the rest of their lives. How their lives are not, how they have both become now the poster child for this thing that they did. It's horrific. Don't Google it. Don't Google it. Stay classy. Stay cool, stay kind, stay classy. I'll see you real soon. I just didn't know if anyone was interested in talking about that, because we can get some people up here on the panel, like other women who are just like, WTF, what the duck? Everyone smash the like on your way out. Thank you so very much. I appreciate you all for coming. Make sure you have your notification bell set to all notifications, because oftentimes I jump on in the heat of the moment and you just won't know about it until you find me.